us break down this mystery. Grab a seat, we guarantee you're in wonderful company, unraveling these mysteries with Mr. and Mrs. E. Mr. and Mrs. E.
Launch sequence activated. Prepare for light speed.
Keeping the missing relevant with Mr. E, Mrs. E. Let's not forget the sweet and E, and of course the best grand E, unraveling these mysteries. Stay a while and share your thoughts. Help us break down this mystery. Grab a seat, we guarantee you're in wonderful company, unraveling these mysteries with Mr. and Mrs. E.
Auntie, is that you? Yes. Bring in the crime dogs. It's time.
Unraveling these mysteries. Stay a while and share your thoughts. Help us break down this mystery. Grab a seat, we guarantee you're in wonderful company, unraveling these mysteries with Mr. and Mrs. E. Unraveling these mysteries with Mr. and Mrs. E.
Good evening, everybody. Welcome to the Mystery Crimecast. I am Mr. E. I'm joined tonight, of course, by Mrs. E and our guest, Auntie. Auntie, welcome back from your vacation, and I'm sure you're happy to be home.
I am happy to be home. It was quite a couple weeks, let me tell you.
Yeah, yeah. I mean, you were really living out of the suitcase for a while.
Yes. Glad to be home.
I'm
So is
sure.
Charlie. She's pretty happy too.
Yeah, it was. Of course, it was great to have you here while we had you, and Granny and everything too. So, so it was awesome. It was it was actually weird when everybody was gone because with the with your dog Charlie gone, and it was so quiet. It was so like Literally and I we the next morning we're like, wow, this is so weird. Just the two of us in the kitchen, because it was there was just all the energy of having the whole family here. So, but anyway, it was great to have you all here. And hello, Bullhorn Betty. Good to see you. Thanks for coming in.
Yeah.
But Bullhorn Betty, of course, a friend of us, and always doing great work.
And she got to meet Aunt E.
Yes, that was exciting. I was excited to meet her. Such a nice lady.
Yeah, I always forget that you don't always get to meet everybody that we get to meet sometimes, So, yeah, and I want to thank all of our mods for coming in. I know we're so last minute.
We are so last minute.
It's great. I was thinking this today. We were like the, you remember at Kmart they used to do the blue light specials. Like
That was
like
the best
blue,
thing about Kmart.
Yeah, you have to be like my age or older to remember this probably, but they used to do the thing where they'd bring the carts through and then just like last second they'd turn on the blue light and it'd be a sale. Like if you happen to be in the right spot, you'd get the deal, and if you didn't, that's kind of what our live streams are like. We usually don't even know until like an hour before we're going that we're doing it, and we have meant to be. Our goal is usually to do at least one live stream a week. And it's just been wild. We've just been so crazy busy the last few weeks.
The last 2.5 weeks has just been crazy for all of us.
Yes.
Yeah, we just could not line it all up. But there were a few times we thought we could, and then
show poodles. Exactly.
Yeah.
Blue light special in aisle 9.
Is Kmart still around? Are they gone?
No,
they're completely gone.
I think they're all gone now.
Yeah, because we Auntie and I bought. I think you and I were dating. We bought stock in
I remember. Because did you? Because you bought it when it was like 25 cents.
Yeah,
right?
it was like 13 cents. Yeah.
When it totally bottomed out, and you guys were like, "I think this is going to bounce back."
Well,
and it did for a while.
I thought when Sears bought it that it would bounce back, and Sears actually tanked too. So it was just everything kind of went down the tubes. The old department store thing was just completely dissolved, and it's a new world. But I loved Kmart. I loved the Little Caesars pizza in Kmart, and I loved the blue light specials.
Well, Just My Girl says that they have one by her.
I think there's just a very few left.
It's like Blockbuster, where there was like that one last Blockbuster somewhere out.
It's
in the
still
Pacific
there.
Northwest somewhere.
It's still there.
The Blockbuster, the last remaining one. Yeah.
Yes.
I actually loved Kmart.
Oh yeah.
Now there was one in Goodlettsville. Is it still there?
No. It
I
got.
don't
You know what I'm talking
It went.
about?
Remember when the flood happened? It went away after that, I believe. Now I might be wrong. But anyway,
there's just very few left, and I don't even know who owns them now.
I have been seeing some questions asking about an update on Middle E. So,
well, actually, we had planned to go live last night, and we had a little scare. We went to the ER last night, and fortunately it was okay, but it was scary enough to go. And so of course, once you get into the ER, even once they clear you, it's like hours to get back home.
yeah.
They just they want to monitor everything, make sure everything's okay. He is in between, and I did see all the orange hearts earlier. I very much appreciate it.
It means
it
so
makes
much.
me smile every time I see them. So
Yeah.
thank you for that. He's in between treatments right now, so he's feeling really good at the moment. And I'm glad that you brought that up, because I do want to ask for prayers for April 22nd for us. That is his first MRI post surgery, other than the one they did immediately after surgery. So this has been about 4 months. So that'll be a big one for us.
Very big.
Yeah. So
Sorry.
if you could keep that in your prayers for us, that date's been kind of hanging out there for us. So much appreciated.
I did look up the Kmart status. It says
She's
that
still
the last full-size Kmart in the continental U.S. closed in Bridgehampton, New York on October 20th, 2024. A smaller location remains open in Miami, Florida.
No kidding.
Huh. Okay.
There are 3 Kmart stores in the U.S. Virgin Islands and 1 in Guam, and that's all
Well,
that's
I
left.
think that's a good reason to go to the U.S. Virgin Islands.
Huh, could be.
Yeah.
I also want to brag on Middle E too, because we just completed a 72-hour fast. And if you've been with us for a while, last month or so we tried to do that, and he was in the middle of treatment, so completing that, we made it to like 40 hours, I think, something like that, and didn't make it to the end, but he did it this time, and so very proud of him for doing that.
That's
So
awesome.
so we
actually made it 74 hours.
Yeah, because
Because of other issues. We weren't able to.
We weren't able to get dinner before, but we would have eaten right at 72 hours, I'm sure, if we'd had the option, but we didn't.
It didn't bother me that bad. It really didn't.
By day 3, it's just kind of okay. It's kind of like, it's like annoying. It's just kind of like annoying. Yeah, we did see some people.
We visited with some people while they were here in town.
Yeah, we came by to say hello. Had a glass of tea, which was okay on the fast.
Yes, we could have tea and black coffee and bone broth.
Yeah. So that's hilarious. Eric with an H.
It was nice to meet you.
And those cheeseburgers and sandwiches all looked great. They did. I gotta tell you. And
actually,
in fact, that's how we came out of the fast. Was a cheeseburger actually, and the bright side to a fast is that first meal tastes pretty good.
It's the best meal
when you
ever.
come out. I mean, that first bite's something else, and you do feel more clear-headed too. We've all noticed that, because none of us had ever gone that long doing that before. So it certainly works that way. Someone's just asked, do we know about a young man missing from Nashville, Mystic Firefly?
We have been really offline for the most part.
Yeah,
because we have been dealing with the medical issues with our son, so we haven't really been. I did not realize that. I think
no, I'm not sure who.
Do you know the name?
Also, I want to recognize we've had several gifted memberships already.
Oh, sorry.
And a couple super chats.
Oh, sure.
Please. I'll start with
Tiffany. It's Tiffany. She just cut it off.
Tiff gifted 1 Mr. E Crimecast membership.
Thank you so much, Tiffany.
Sped teacher gifted 5. So thank you so much.
Thank you, Sped teacher.
Thank you so much.
I am so glad we got to meet. It's great when you get to meet people in real life.
And she's so sweet. So sweet.
That's the word on the street about Sped teacher. Everybody talks about how sweet she is.
It's true.
That's so.
It is
awesome.
true. That's what everybody says.
And Lisa Be Always has been a member for 7 months now. So thank you, Lisa Be Always.
And she says thanks for everything you do for Sebastian.
And then we have Opal, who's been a member for 2 months. So nice to see you all. Thank you so much, Opal.
Thank you, Opal.
Did you see Detective Mom?
Yes, it's super weird when you all are all gone, and it's kind of weird. We get used to being on. Yeah,
we kind of get used to like it's so funny. I mean, like we're away from each other.
Mm-hmm.
There's distance, and it's really names on the side of a screen. But it's like when we were waiting for the show to start, you're seeing everybody talking in the chat. It's like, oh, there's War Damn Eagle and Mystic Firefly and Dreaming of Blue Skies. It's like old friends getting back. It's kind of
it is.
I've said it a million times if you've been with us, but this was the part of it I did not anticipate doing the show like this, was how the community part.
Well, how attached you get to people.
Yeah, I didn't anticipate that. I just didn't realize that you would kind of develop all these relationships in different ways, and so that part of it's been surprisingly great. And thank you, Detective. Whose name was it?
Detective Mom.
Detective Mom.
Thank you so much, Detective Mom. And Sharon Marlowe gifting $5. Thank you so much there. Have you decided if you will be covering the When There Is No Body article? Yes. It was really good. Prayers for you all. Yeah, I don't think I've talked to you about this.
I let him take over the X account, and if there's anything weird going on there, that's all him.
Yeah, it's something I reposted from I don't know this.
I'm sure you didn't tell me.
I don't know if I can Well,
No.
yeah, I'll talk to you about it later. But yes, it was
Do you
someone
want
I
me to mute it?
Yeah.
Okay, hold on one second. Let me find out what in the heck he's talking about. Okay, we're back.
Well,
Sorry, guys.
I'm glad I asked. But yes, I will be. I actually my plan on this was such a good article. It makes so many great points that I think I want to do a whole live stream just on this topic. And
I have not read it all yet, but I did see that you shared that, and I thought it was very interesting.
Yeah, I think we could do a whole theme just on that article and kind of keep referencing it, but then use other stuff, use this case and apply it to that article. So,
Well,
yeah, I think so, Sharon. Thank you,
And
War Damn Eagle.
War Damn Eagle, 6 months, member.
Oh, thank you so much for that. Appreciate it. And I don't know, did we thank the mods for being here? I see Castle, Kelsey, Dreaming of Blue Skies. I think there's probably a few more. But thank you so much for helping us out tonight.
and Dreaming of Blue Skies.
Yes. Dreaming of Blue Skies member for 9 months.
The
Thank you
sweetest
so
member.
much. Yes.
Most supportive, sweetest.
Absolutely.
And Terry F, member for 7 months. Hello. Good to see everyone.
Good to see you.
Yeah, we do appreciate the support. Thank you so much for that. And we appreciate all of it. It's good to see
Aw.
everyone back.
Ginger for we love you back.
She's a
Aw,
great
that's
mod too.
Yes.
So
And Kelsey, member for 6 months. So we've got some of our great mods in here tonight, and they have been members with us for a while. I think
We
that's got
appreciate
us
you
caught
guys.
up.
I didn't even realize we've been around that long. You know how I am. It feels like it just started, but then it also feels like it's been forever.
I know. It does. It feels fast to me. It
It-
feels fast. It does not feel like it's been this long.
Aw, Deanna, thank you.
Thank you so much.
I didn't
Deanna.
realize it. I didn't realize we'd be so like missed. Just like taking a week. What? How many
We've
weeks?
been going like 3 weeks.
Oh, have we?
Yeah, it's been.
Well,
it's been 3
we
weeks.
did it the night that I got there, if you'll remember.
Yeah.
And then I was there a week, and then I was gone a week, and now I've been home for almost a week.
Oh, that's hysterical. I
Yeah.
did
So
not
it's been
realize.
It
like
really
3
is.
weeks. Yeah.
Yeah, we
almost.
just a couple of times thought we had a window and then just couldn't do it.
We've been
Yeah, it's just busy.
yeah.
Oh, Don B. Mystic Firefly says, bet Don B knows the details of the young man missing from Nashville with similar cases, Sebastian.
Oh, really?
And so you'll have to fill us in later, Don, about that.
I
so we
think
can get up
Don's
to
in
speed.
here.
He is here
I just
somewhere.
saw
I just saw him go by. He was talking about. I think he said something about riding his lawnmower. Yeah. Hey guys, been out on my new riding lawnmower. LOL. But good to see you, Don.
You could come do our lawn. It needs help.
Yeah, it does. It needs more than just a lawnmower.
Sassy T member for 5 months.
Oh, thank you so much, Sassy.
Oh, and
Love it.
Just Irish, I'm so sorry. She said, I'm watching but can't chant for 40 more minutes.
I'm so sorry. Okay. I'm so sorry.
What does that mean?
Well, I set it to 60 minutes because I was trying to keep, it calm in here.
Yeah, keep it from getting too crazy, right?
Yeah. I can maybe turn it down a little bit. I was getting a little aggressive.
Yeah. So I mean, and I guess we could just go ahead and get into it, right?
Yeah.
So we
one thing, the plan tonight was to go and do a second live. I'm not 100% sure I'll have the energy to do that.
Yeah. So we were
told him we
thinking,
might.
yeah, it just depends on how fast this goes. It's we're gonna go through the end of the RICO injunction and the decision and kind of what we think the repercussions are there, kind of how things happen going forward. We're gonna read the judge's statements. I love a good document read anyway, so that's always fun to me. I haven't read all of it. I got through about a third of it, just enough to kind of get the gist of where it was all going, and then we were thinking it's about 26 pages. It probably won't take us much more than an hour or so. That we would just stop that live then and then do a Sebastian one, because we haven't really talked about Sebastian
And so long.
and because with the last two lives we did were kind of back to back, and it was just reading the new filings.
Mm-hmm.
And so really it's been probably over a month since we did
Yeah.
anything just, related to Sebastian. Also, there's so much that's happened that we want to talk about.
Yes.
And kind of give our own opinions and takes on what it all means, So we'll just see if we have time tonight, and then and how Mrs. E's feeling too.
And before you get started, Just Irish, thank you for that super chat to let us know that you couldn't chat.
Yeah.
I just changed it for you to 20 minutes, so that it shouldn't be much longer.
Yeah, she's on there.
Okay,
Yeah,
good.
I've heard Just Irish a few places. Very, very funny lady. I like to listen to you. So I don't know if you have Just Irish. Does she have her own channel, or do you have a place she regularly appears?
We've heard her on Brittany's.
Yeah.
Mhm.
Yeah. Okay. So, but does she have her own channel? Not that I'm aware
I
of.
don't think that she does actively. No.
Okay. Well, anyway, but glad to have you here.
Welcome in.
And Nana's Dragonfly.
Nana.
Thank you for being here. And I just want to say, I was listening to a little bit of you guys with Brittany while I made dinner, and I'm sorry to hear about your cat. So that I know what that is like, and you've got a lot going on. I'm sorry to hear it.
And her husband has pneumonia, so we need to all send prayers to Nana for sure.
Yeah. So I'm sorry to hear about that, but we'll. I know it's tough with the pets, and
I didn't tell you this. I bought a book at the store today to start writing down all of our prayer requests so that we can go through those together before we go to bed. What do you think?
Well,
That's a great idea.
Great idea.
Mm-hmm.
I think it's a great idea. All right. So maybe what I should do is just kind of give because I know a lot of you have followed this with us, but some of you are kind of new to our channel, and maybe have joined on in the last month or two or whatnot. But just to kind of give a background on how we got here and where this all started. Essentially, roughly 6 months ago, they filed Atnight, Dog the Bounty Hunter, a few YouTubers, and Seth Rogers, all filed for an injunction in Pennsylvania, seeking relief from the filing was a civil. It was alleging a civil RICO allegations, and it was massive. It was a ton of allegations. We read through all these filings. You couldn't dream of ever reading through all the evidence because it was thousands of pages by the time it got finished. And at the core of it, they were alleging that the defendants were part of what they referred to as an enterprise, and it was a combination of people from social media and TikTok, YouTube, and such, and that were listed as does. And then the two key defendants were a YouTube channel called Granny's Watching and a TikTok channel, Barbecue Lady. And because I'm assuming because they lived in Pennsylvania, and that's where the suit started. Over time, the case kind of just sat there. For a long time, it went without a judge even being assigned to it.
Mm-hmm.
We check on it once in a while, nothing had happened. And then about 2 months ago, the defendants filed a anti-Slapp motion. And so there was a hearing, and that concluded. And then we kind of waited, thinking something was going to happen within a week or two or whatever. Turns out that they have a full 60 days to bring back that ruling. And I think it happened on day 59, maybe.
Was it 60 days?
Has it? It seems like that's been a long time ago, right?
I can look.
Because so anyway, after that happened, there was maybe I'm wrong about the timeline.
I'm sure.
It's been a long time.
War Eagle or somebody in chat will know.
So then the plaintiffs filed for the emergency. What was it called? An emergency hearing.
Okay, wait. There's an echo. And
I thought somebody was helping me out. I could hear myself.
My phone was acting up, and I had it turned down, but it wasn't all the way.
I was like, who's calling in to help me out there with the
it was actually you, but you were on a delay. Sorry about that.
Oh, War Eagle. I was saying, how long? What was the question?
When did that hearing happen? The one in Pennsylvania where they were all there in person.
Like what date
the
did that happen?
anti-slap hearing where they were all there. I can't remember how long ago. I think it's been 2 months, but I might be. Sometimes
Oh,
I'm-
you know, you
Wild.
might be right.
um
Because I didn't even know we'd been gone 3 weeks. So
yeah. So I it's been something like that. But anyway, so that the decision was finally made yesterday, and even though this emergency hearing, I can't think of what it was called, but anyway, whatever the emergency hearing that they had requested from on Atnight's behalf, it was sitting on the docket,
Mhm.
and and when that happened, that's the last time we were alive. Hong was posting on X that he believed that it would be heard anytime in the next week or two, and we kind of waited, and then 2 weeks go by, nothing happened, and nothing was happening with this anti-slap. So everybody's kind of wondering what's going on here. And then yesterday, the judge just made a decision on all of it, on the anti-slap, on the initial injunction, and on this emergency hearing. And she does explain why she does it that way in her written statement.
Mhm.
So rather than me butcher it, we're just going to end up reading it, so that way we kind of understand how she came to the conclusion.
Thank you, War Eagle. Gosh.
It's been highly contentious. It's been very controversial for the last 6 months.
Mhm.
It's been very emotional for people, whether you're for various reasons, for whether you think whichever parent you kind of side with or have more sympathy for, whichever how you're viewing the case. Some people think it helps or hurts Sebastian's story in various ways, depending on your point of view. For some people, it just kind of became about defending their favorite social media outlets and such. And so it's been very, very contentious. So it's really, really just a toxic environment overall. So anyway, so we finally though do have some resolution to that, and the kind of three key decisions are that the original injunction, the whole RICO file, the bit that that started us all, that was dismissed, and then the emergency hearing was also dismissed, and then the anti-slap was granted, and the that was filed, of course, by the defendants. And if you're not sure what that anti-slap is,
Yeah, people were asking you to explain it.
yeah, I saw that earlier because I wanted to go over what the anti-slap is it's a free speech extra free speech protection type of law. I think 31 states have one of these now. And the idea is that it's to protect defendants from someone just putting lawsuit pressure on them for the sole purpose of just silencing them, quieting their opinion. So that was the defense, and that was really just the defense of their majority of their defense for the position anyway, is that they the defense basically believed this was a First Amendment issue, free speech, that for the plaintiffs largely it was their speech is crossing over into not protected speech, right?
Yeah, I just
You
didn't
got
know
a
if
question?
you wanted to address that.
Oh, I'm sorry. KC, hello to the fabulous Ease. Good Friday and happy Easter, all of you. Driving, pulled over to say hello. Thank
Hi,
you,
Casey.
KC.
That's not what I was talking about. It's on your screen.
I have no idea.
Up higher? No, you don't have to show it. I'm asking you to read it.
Okay.
Because you didn't say those things. That's why.
Oh, well. Right. So, well, that was part of so if you're talking about the stakes, so one of the things that, could have happened, as we stated with the RICO part of it, the civil RICO case, if it had been successful, it had moved forward. The idea is that if it's successful, you are basically laying out the evidence for a prosecutor if they are interested in taking it to a criminal level. So you're kind of like, it's kind of like you're doing all the work for the prosecutor in that jurisdiction. And then of course they have the option whether or not they want to do it or not, but you've kind of already done the work for them. So they would look at it and see if they think, if it's successful,
right,
and they feel compelled to do it. Of course, it's just their choice, but that could have escalated that way
I think we were just
if it had been
speculating.
successful.
Yeah.
Right. I think this is how we explained it before. Obviously,
But-
it's a civil case, so it was a
Yeah.
civil RICO. So no one's going to prison if the plaintiffs had won. What could have happened is that because you lay the evidence out there, if the prosecutors feel like this is something we can take to a criminal court, you've already done the work for us. I mean, the work is in the putting it together, the research, the evidence, whatever, and then they kind of take the ball and run with it because you've made it sort of easy for them. That's kind of how that was kind of what we laid out, I don't know, 6 months ago or so. But yeah, at this point, no, I don't believe anybody will be facing any kind of criminal charges for the RICO. I mean, it would be shocking if anyone, if that happened at this point, because they got dismissed. So no one's tested the evidence, no one's heard it. It's not going anywhere at this point. There will be possibly appeals. I don't know. I might talk about this after we do the reading from the judges and all of that. But I don't know what the options are for the defendants. The plaintiffs, it seems pretty clear they have an option to appeal if they choose to. But for the defendants, I don't know if they can. I don't know what avenues they have to alter their decision because it. But we'll kind of get into that as we read it and try our best to understand it. And I should preface this as always: none of us are attorneys. None of us have studied law. We are just lay people reading documents like everybody else and trying to do our best to understand it. So yeah, we'll talk about kind of how effects after we do the read. I think like how things go going forward. But let's see. And one thing that was kind of difficult with the anti-Slapp is there was no precedent in Pennsylvania, so we really didn't know what to expect. How one of the things that surprised me about it is I thought my assumption of how it would work was if the plaintiffs had their case dismissed, which is what happened, and then if the judge had ruled that the anti-Slapp could go forward, that it would then be a new hearing. I didn't know that it would be a decision at that point. I assumed there would be a new hearing to decide the merits of the anti-Slapp, but that's not how that works. So she actually made the decision, so it's all over. There's no more hearings without, at least best I can tell, unless there's some kind of appeal on that type of thing. I hope that makes sense. And if I'm wrong about some of this, feel free to correct me on it. That's just the best I've understood it.
Okay. Can I talk with you for just a second?
Sure.
Okay, hold on. Aunt E, if you want to address chat for just a second.
Sure. Let's see. Let me go down to the bottom. And yes, we do appreciate no drama in here. We're just really here to read the facts and get to the bottom of things and be fair and honest in the way we report it to you. Thank you, Ginger, for Ob. That's such a sweet thing to say.
Okay.
Now you're back.
And I know that, like I said, I know this is highly, people are very divided on this. It's been extremely polarizing. It's been kind of tribal, really, for the most part. But I know everyone has strong feelings about it. If you're new to our channel, our approach to all of this is, if we're going to talk about creators, we just talk about them in a neutral way or a positive way, but not insulting and that kind of thing about creators. And then just in general, insults, trolling kind of stuff like that, we just remove them.
Upsetting our regular chat.
Yeah, upsetting the regular chat. If you're here to cause trouble, then you'll be asked to leave. If you just want to if we're just trying to understand the ruling, really more from a, I was thinking about this today. To me, what's the difference for me between like a post or a comment that to me is like, nah, let's just get rid of them or keep them. And for me, it's when people want to debate. It's the difference between wanting to debate people or ideas. And when people want to debate people and do personal attacks and stuff like that, I don't care about it. I just go somewhere else. Is the way I see that. So I just want to discuss ideas.
I know. And I will tell you what's going on is they're trying to, because we decide to block people, they're making a big deal about us blocking people and upsetting our regular people. And it's people we've never seen before.
Okay. Well, then, yeah. So keep blocking those people. Is that okay?
They're just here to disrupt. And you know, I think that our regular people who've been following this all along deserve to hear you read the documents and go through it.
Yeah. So. We don't do drama here. So, that's probably about the most you're going to get out of us. Actually, that 2 minutes.
Yeah.
So, we're going to go on and read it and just do our best to understand it. And if you want to hang out and you're not normally from this channel, then you're welcome to stay. I mean, you're welcome to even have your favorite person that you like and support and whatever. And we'll talk about who the real winners were and that kind of thing at the end. And the defendants should feel great today. I mean, they really should. They in a way, their stakes were higher than the plaintiffs, because of that hanging RICO. And I know if I were in that position, even if I thought it was a long shot, I would be glad to have that door closed. I just would. And so I'm sure they're feeling great about that, and they should feel relieved. And so we're just gonna look at it as the merits of the case, what we kind of think strategy wise about how it was all put together. How the judge came to the decision, what the logic was, because we don't really know. We haven't read the full thing yet. So we're just going to do that together. But yes, mods, if you would help me out with that. If somebody's, me, I'd rather have a peaceful, thoughtful, idea-centered chat and live stream than more views and
we don't care about that.
I'd rather, because that's part of why we started the channel, is we wanted to have a place where it was we could talk about these cases in a less tribal way, in a more logical, fact-based, truth-seeking manner.
Right.
If you're into that, we're a great place for it.
If not,
then that's okay. You can find there's other places.
And talking about our choice to give our mods or us the power to block somebody, that's not going to get what am I trying to say? That is not going to get a response out of us. So I would, just so you know, anybody that's in chat and if someone upsets you, you do have the ability to block them yourself, and so you don't have to see their stuff. So just keep that in mind. But I will. I'll go back to an hour if I have to. Or 2 days. I'll pull a Betty. Betty did one for 3 days or one time or something. It was so funny. But Betty actually had a good point.
Bullhorn Betty says no one has a right to chat. You have a right to watch if you so choose, but if you chat, you better do it respectfully. All opinions are welcome respectfully. Absolutely. I love, actually, it's hard to find, but I love a good debate with someone that I disagree with if they're intellectually honest and respectful. I'm always up for that. And we've had several of those over the last year doing this with people in the chat and such. It's not about disagreeing. It really just usually comes down to manners and respect. But let's get away from that even. I don't want to spend any more time on that topic, if that's okay. Let's just get into the document, because I think we all like to see it ourselves. I'm sure most of you have not read the full thing, and we'll just kind of see what we think of this together. Do I need to be the one to pull that up, or do you launch it?
I have to launch it, but I'm trying to mod at the same time. I apologize.
Sorry. I gave you the big
Sharon
build up.
Marlowe. Aw, Sharon. She's so sweet. Thank you so much, Sharon. That is very sweet. And she says,
no drama dollars to be made here, trolls. They are not playing tit for tat dollars game.
No, we're not. The only problem is when I do it like this, I can't really make it any bigger for you.
Okay. Can I make my screen bigger? Is that okay if I do that? Or
usually I have it printed out for you, and it didn't occur to me to print it out.
I can read this. I just don't want to lose the chat if let's just see what. Oh yeah, I won't be able to see it. I can read that though. When you're reading, you don't pay attention to chat anyway. No, that's true. So
that's why I'm doing that.
All right. So I'm not sure where to start here, but so obviously this first page has all the the plaintiffs and defendants. So that's just giving the date. We don't really need to do that page.
Hi, girl mom. Welcome in.
Okay, so yeah, we probably should start here.
And you can move the pages?
Yeah, I can move the pages.
Perfect.
It's working, I think. All right, so I think we could just start right here. So this case relates to online podcasts hosted by defendants Barbecue Lady and Granny's Watching. And when I can, I substitute handles. On which Barbecue Lady and Granny's Watching and members of the public who choose to log on to and or participate in the podcast through live sessions and or chat rooms discuss true crime investigation and proceedings of national significance. Specifically, the podcast at issue in this case relate to the case of a missing Tennessee child whose father, Seth Rogers, has utilized both television and social media to find said missing child. In those efforts, Rogers has coordinated efforts with dozens of other persons, entities, and authorities, including but not limited to the other 9 plaintiffs in this action: a media company, a television personality and bounty hunter, and various social media personalities, YouTube broadcasters, podcasters, and online personalities. Plaintiffs' complaint against the defendants' podcasters and 50 Doe defendants alleges that defendants' statements and conduct on their podcast give rise to civil and criminal liability and purports to allege 47 counts against the defendants, including defamation, harassment, intentional infliction of emotional distress, cyber stalking of a child, and cyber harassment, civil conspiracy and coordinate defamation, criminal conspiracy, interference with prospective business relations, as well as alleged violations of the Pennsylvania Corrupt Organizations Act and violations of the Racketeer Influenced and Corrupt Organizations Act, and violations of other criminal statutes. The complaint seeks any injunctive relief. I should have read that earlier when I was trying to do my
research,
my summary of how we got here and what the case was. Little did I realize that was just right there in front of me. But anyway, that does actually sum it up pretty well, what the original injunction was all about. Defendants do not dispute that they have discussed the search for the missing Tennessee child during their shows, but in their separately filed and above referenced motions, pursuant to Pennsylvania statute, anti-Slapp motions assert that the lawsuit is, so that SLAPP, it stands for Strategic Lawsuit Against Public Participation, designed to chill their constitutional rights to free speech. They are immune from liability for their conduct and speech on the YouTube podcast under Pennsylvania's recently enacted and so-called Anti-Slapp statute, and that the complaint lacks any merit and must be dismissed pursuant to Pennsylvania's Anti-Slapp statute. Defendants' Anti-Slapp motions were taken under advisement after statutory required oral argument at a hearing on February 18th, 2025. Well, that answers that other question we had. So I guess it was 2 months ago. That was that hearing.
Okay, next time I'm printing it out. So because you read it when I print it out. Like you read it like front to back before.
Well, I did read this yesterday, but I wasn't
just
looking for the.
I got you.
I was trying to.
You were kind of get to the nuts and bolts of it.
And there is something interesting also, just in general with this. There is sort of a parallel between this and the Bullhorn Betty situation.
Yeah, it is. Yeah.
In a way, it is a similar. There are comparisons you could make. I mean, they're different. It's a protective order versus an injunction. So, obviously, there's different circumstances and everything. But at the heart of it, the defense is your right to free speech and what crosses that line on the plaintiff's end. So it is kind of interesting that way. Hobo's Life, thank you so much. Thank you to all the E family and Dawgs for the prayers. Much love. Surgery went great. In home doing good. Long road ahead. How is Middle E? He's doing great. Well, Hobo's Life.
And if you don't mind, real quick, Women's Warrior was saying I look very tired. This is not my color. That I look very sleepy tonight, and she's wishing me restful sleep tomorrow and a brighter day. Really, I am tired from being in the ER most of last night. So
that went for a long time.
Yes. So with our son, so I was there a really long time, and it wore me out. And so, but I appreciate your concern. It's very sweet. And this is definitely not my color. It washes me out big time. So, but thank you. I appreciate it.
Let's see. So we got to the date. And by separate order, the court has granted defendant. anti-Slapp motions dismissing the complaint and thus terminating this case. As such, plaintiff's emergency motion for protective order and to enjoin unauthorized recording, broadcasting, and doxing filed on March 26, 2025 is denied as moot, as the case is no longer an active case. Right. So this was right. So this was that one where they approved it for a hearing, the filing was approved, and then it was sitting on the docket, and we just waited. And we got into that third week and kind of thought, okay, what's going on? No decision, no dismissal. It was just hanging there. And just by definition, you would think an emergency hearing would happen, less than 2 weeks, you would think. But that didn't happen. But this is why. I'm assuming, I guess the judge probably was getting close to their decision, knew they were going to deny, and that's why just didn't do anything with that hearing, because she knew that she was already going this direct. Because she took 2 months to write this, and it was I suppose this is going to be likely case law, because this is the first anti-Slapp in the state, so they had to be you want it to look right and want to do a good job with it, I guess. So anyway, so that was why that got denied, and why I'm thinking that's why it didn't happen until that day. Does that seem likely? I mean, that's just what I'm inferring from that.
And also, I wanted to say, Hobo's Life, I'm very happy that your surgery went well, and prayers to you.
Yeah, and yes.
And thank you for that super chat. That was very nice. We'll do the songs at the end. They get overwhelming sometimes, so we'll just wait and thank everybody all at once, if that's okay. And hey, Josh, welcome in.
Oh, hey, Josh, good to see you. Okay, so alternatively, this court determines that plaintiff's March 26 motion lacks merit. That motion requests emergency injunctive relief based on alleged conduct on the February 18th, 2025 court hearing, which the motion suggests is violative of Pennsylvania's criminal statute, rendering unlawful the use of an audio or video device in court. This court has reviewed all 107 pages thereof, the 505 paragraphs, and the accompanying 446 exhibits, and finds that not one page, paragraph, or exhibit allows the court to conclude any named defendant engaged in an unauthorized recording or broadcasting of the February 18th, 2025 court hearing before the undersigned.
Our son's in a good mood tonight.
Yeah. I always love the happy sounds. There is no exhibit or evidence that demonstrates that any named defendant disseminated any video or audio or in any other way broadcast the actual courtroom proceedings on February 18th. Plaintiffs have not pointed the court to any rule of civil procedure or case law that prohibits a party from publicly discussing a case or courtroom proceeding where there is no existing so-called gag order in place.
Some of our subscribers and people in chat also enjoy his sounds.
It's hard.
And actually, I wanted to mention this earlier, just real quick. Scotty Too Hottie had the funniest comment earlier, and we were laughing before the show started, and we forgot to mention it. But anyway, just Scotty, you made us laugh, and we appreciate that right now.
Yeah, so. This is one I don't know. I'm not quite. I guess I haven't looked at the evidence, so I don't know what they submitted. But
they're basically saying there wasn't any evidence to show that.
I mean, the thing
even
is,
though there's all these pages supposedly.
It's weird because I mean, I don't know about.
Yeah, that's
some of it we saw,
yeah,
and they talked about it. So I don't know, but maybe
Tiff said.
I know. Maybe it wasn't enough. I don't know.
So I don't know why, but that's
No, I don't think that's right. I think there were 7,000.
She says there's exhibits. She gave a number on the last page. She said 440. Or is she referring?
Reviewed all 107 pages and 505 paragraphs and the accompanying 446 exhibits, and finds that not one page, paragraph, or exhibit allows the court to conclude that any named defendant engaged in the unauthorized recording or broadcasting.
Yeah, I mean,
so
I don't know.
Thank you for the super chat, Demon Chihuahua.
Of course, I don't know. Maybe they hadn't submitted that because they assumed they would get to when the hearing happened, or would it work that way? You'd have to submit it with the file, I guess, right?
And I think
I
there's
don't know.
there's some more jargon about the exhibits later on that might clarify it.
Okay.
Ginger
Yeah,
says
maybe.
read them literally. I think it's 7,000 pages, right? If there's 400 and some odd exhibits, I believe it's 7,000 plus pages.
Yeah.
Yes.
Well, I don't know. So anyway, whatever she looked at was not convincing, or she didn't see anything that made that connection. So anyway, there is no such gag order issued by the undersigned or any other Delaware County Court of Common Pleas judge in the above captioned case. So they must have referred to a gag order, and she's saying there was not one. There has been no reference or any alleged misconduct at the February 18th court hearing to Delaware County Criminal Investigation Division, and the undersigned is unaware of any criminal proceedings initiated to enforce the criminal statute invoked by plaintiffs in the March 26th motion. Therefore, the March 26th motion must be denied for the further reason that it lacks merit. Okay, so this is the 2-page one, or the shorter one, right?
Right.
Or is there
Yeah.
okay.
So
that was about the.
This is the shorter one. I didn't mean to. I didn't know which one I picked. Sorry.
Yeah. So I just want to make sure which one we're reading. So this is order denying plaintiffs amended emergency motion.
This was just about the court case. This is just about the illegal recording. So this isn't the actual. I mean, they're just dismissing this portion of it on this document.
Okay. So this basically explains why that emergency hearing was denied. Right. The last.
Yes.
Yeah.
Regarding the recording,
denied is moot is how she phrases it. Okay. So that's that one. So the next one is is the longer one, about 26 pages or so, and that'll get more into the big injunction and why that was denied.
Yes, give me just a second. You all talk to chat while I'll pull it up.
Sure. Let's see. I'll just. I don't know what you were referring to. Tina Girl says chat is crazy tonight. I'll be listening, going to the bushes.
Yeah, I don't blame you.
Yeah, hopefully it'll calm down. Yeah, they didn't broadcast the court. Someone took a pic, didn't realize it wasn't allowed, and apologized to the court. That was it. Not the big deal Atnight made it out to be.
Yeah, well, we weren't there, so we don't know. We've heard two different stories. So.
Yeah. Well, I mean, but
that's why we like to go to court.
I don't know about video happening in the court, but the picture I think everybody saw. And if they, if they kind of said, hey, we didn't know that was obviously, if they don't want to press any kind of criminal.
Did I put the same one up?
That's the same one.
What in the world is going on? Okay, hold on.
But that happened. And so, maybe she doesn't think that was,
but yeah,
but it happened. They could not press, charges against it, but that's their choice.
Well, I think people are saying during the court proceedings, but I think the rule in that courthouse is no photography whatsoever in the courthouse period or video, right?
Yeah, that was our understanding, is even in the hallways and stuff.
So, but I mean, we weren't there. So,
but laws and things like that, rules like that are really kind of just as strong as your willingness to enforce it.
Right.
So
we were talking about that today.
Yeah. I mean, I think about this all the time. There's laws broken all the time. People commit crimes all the time, and you don't get prosecuted for all of them. I heard did you find the thing?
Oh, where was it broadcasted? I believe they were on another person's another person was live while they were in the courthouse.
Yeah, that was. Yeah. I think that was the allegation there.
Yeah.
That they were giving live updates and that kind of thing. So,
well, yeah, Just Irish said, I clearly heard court proceedings aired in real time. So there's that.
Yeah.
So,
and I haven't. Yeah. So, but anyway, it wasn't persuasive enough to the judge, or I don't know, whatever reason.
And our mods are just confused as to how to handle chat because there's so many differing opinions tonight. So do you want to just maybe give them a little more clarity on how to handle chat again, as far as people and their opinions?
Yeah, I mean, I'm seeing different opinions, and most of what I've been reading is okay. But of course, I haven't
There's
seen
several
all
that
of
have
it.
been deleted, so I just want to make sure everybody understands.
Yeah,
As long as if it's a differing opinion, as long as it's respectful, that's fine.
yeah,
You don't have
absolutely.
to delete them or anything like that. But if they're being attacking other, um, viewers and they're being rude, of course, time them out. But we just want everybody to be respectful,
Well,
and we respect you, and we respect your opinion.
Kelsey says, I feel there's too much blocking going on for non-drama statements.
I agree, Kelsey. There's a lot of blocking going on.
Okay, so you think we're being too heavy-handed with it?
Yeah, I think if they have an opinion, it's fine. It's fine as long as it's respectful and and it's their understanding of something. That's fine. It's just not being rude to other people or making blasphemous statements against others.
Yeah. Yeah,
Right.
it's just we wanted to,
I think, we're used to a very peaceful chat. And so I think some of our regular people want to keep it peaceful, and they recognize people from, channels that
right.
are not so nice,
Yeah,
to
yeah.
us.
I get it.
So,
I get it.
or to people in general, other people.
I do
So,
get that.
but,
Reputation precedes everybody, right?
right.
So
Exactly.
yeah, I understand. But anyway, let's just keep going with it. Can we pull it up, or do you have it ready?
I do.
But what I was going to say, I'm reminded of this all the time. I think of I heard this FBI agent talking once, and he said every day, any American is committing an average of 1 to 2 crimes per day, and they have no idea they're doing it.
Oh, really?
Just a variety of different, like just things you might do that you don't realize are crimes, and how you handle your
Like
paperwork
littering?
or life or whatever. But
I'm just kidding.
And actually, what his point is that what he was talking about was law enforcement shouldn't target people. Law enforcement should investigate crimes and not people. He was like, because what he was getting at was if you go, I want to go find out about this guy, they can find a crime on you, because some people are committing crimes all the time, don't even realize. And so anyway, but there's lots of crimes that occur that just never, never any actual arrests or conviction, trials and all that. But yeah, let's go ahead and do the next thing.
And I also forgot to mention it is Good Friday, and happy Good Friday to those of you out here.
Yes.
Let's see. And let's see. I've got it right here. So there you go. So this is, I think that's the correct one. This is the granting. This is the longer one. I think it's 26 pages.
Okay, so this is an order granting defendants motions for dismissal and requiring plaintiffs to pay defendants' attorneys' fees and costs under the Pennsylvania Anti-Slapp statute. All right, so that's just all the date and all the players. So we'll skip that part. Yeah, it's just giving the dates of everything happening. Boy, and I can't read that tiny part anyway, but I don't think it's. Is that relevant? Okay. Actually, it might be. Yeah, I might need to read that. I'll just lean in here a little bit. The court was required to hear oral argument on the anti-Slapp motions no later than 60 days after the filing. The anti-Slapp motions were referred to at the undersigned on February 12, 2025, and a notice of oral argument for the next possible open date on the undersigned's calendar, February 18th. Was both emailed to counsel for all parties on that date and submitted for docketing on that date. The notice appears to have been entered on the docket on February 20th, 2 days after all parties appeared for the February 18th argument. Although the parties were provided the opportunity to provide supplemental briefs in support of their respective positions pertaining to the anti-Slapp motions, only defendants elected to make additional written submissions. Despite identifying 10 plaintiffs in the caption of the complaint and in the allegations identifying the parties, only one plaintiff attempted to verify the complaint, and that is Atnight Media, through its managing partner, Hongji. This purported verification is undated, and there is no indication in the verification or elsewhere in the complaint that Mr. G, on behalf of Atnight, had personal knowledge and or information with respect to any and all of the other plaintiffs who purport to bring claims against the defendants through the complaint, to be able to verify the complaint on behalf of the other 9 plaintiffs, nor is there a statement as to why there is No verification provided by any of the plaintiffs other than Atnight. Moreover, yeah.
Since you're just starting the 26 pages, I'm so sorry to interrupt you, but we have the Sebastian live starting at 8:45. So would you like to push that to Sunday?
Yeah, I think so.
Okay. Sorry, guys. I
Yeah.
think we're going to push the Sebastian one to Sunday or Saturday. I'm going to put it Sunday for now, but we might find time tomorrow.
Yeah.
I think we may have. No, we don't.
Well, Sunday's Easter, so that's going to be hard for some people.
Oh,
Unless we
that's
want to do it
true.
in the evening.
We could.
We have Easter plans tomorrow too.
We do.
We have Easter plans on
But-
Sunday.
But we won't be out late.
We have plans.
You have
because-
plans tomorrow evening?
No.
Let's
Yeah.
shoot for tomorrow evening then.
Yeah, tomorrow's good, but Sunday's not.
Okay. Is that okay?
Yeah, I think so.
Are you sure?
Yeah.
Okay.
And we'll make sure we give everybody 5 minutes notice.
Yeah.
So just to kind of stay.
I just think it would be better because you're not going to be able to give this your full attention to try to rush through it.
Yeah, yeah.
And we were being ambitious, thinking we could do it quickly.
Because we've been doing lives where it's like, 100 pages. No
Mhm.
problem. 26, we could do like a reel.
And I
put it
apologize,
on
guys,
TikTok.
that if anybody was looking forward to that, we will do it tomorrow night instead.
And that one can be
And-
really big anyway, I think. We've got a lot to cover.
Yes.
Can I share this?
I'm going to set that for 7 tomorrow. Is that okay? Or 6?
Yeah, it's just 7 because
Yeah.
probably, yeah. All right. So I lost my place here.
I apologize. I just realized the time and I knew that we wouldn't be making that. And I didn't want anybody to be over there waiting for us.
So I think I'm here. Plaintiffs filed 2 responses, each with the same timestamp to the Trude motion, both of which contain not only verifications from the plaintiffs in this action, but also from I don't know who these people are, but Michelle Klubine and Kenneth Klubine.
That is the tacos.
Oh, the Taco family. 2 individuals who, like dozens of other non-party individuals and or entities mentioned in the complaint, are alleged to have played some role in some aspect of this case. It is not clear why verifications from the Klubines were attached and or how the Klubines could verify that the representations in plaintiff's response to the Trude motion were accurate and truthful. In addition, plaintiff's untimely response to the Anti-Slapp motions, unlike their complaint and injunction petition, both of which included the name of Attorney Attorney Lesniak and another attorney, Bruce L. Castor, above the caption, not only included verifications from each one of the plaintiffs, but also were submitted with only Attorney Lesniak's law firm on the submission. Finally, the court notes that all of the responses improperly attempt to change the caption in the case to add, without agreement of the parties or court order, a new defendant, SF investigates, and to change the number of Doe defendants from 1 through 50 to 1 through 14. The court notes that the same plaintiffs filed also on October 18, 2024, a petition for preliminary injunction and final injunction and other equitable relief, which was filed without any verification from any of the plaintiffs. The injunction petition, like the complaint, also lacks any exhibits. In addition, no certificate of service was appended to the injunction petition. As such, the injunction petition was not referred to the undersigned or any judge of the court. So it looks like there she's kind of laying out the technical paperwork aspect of miscues, right?
Can I answer Kelsey real quick?
Sure.
Hey, Kelsey, that's not a real picture. Just so you know. I think it was a joke picture.
I wasn't sure.
Really?
I don't know. Was it a joke? Was it AI?
If it's not, okay,
I
maybe.
really don't know.
Okay, I thought it was a joke. Maybe I'm wrong.
Was it a joke? Is Josh still here? He would know, right?
I think it was on X, wasn't it?
Oh, it was War Eagle saying it is.
Oh, my stars.
Oh.
Well, then I'm wrong. I thought it was a joke. Every time I saw it, I thought it was one of those AI pictures. Oh, my stars.
I mean, it's like he could start a new life.
Yeah.
Like growing his hair out. Like it makes
looks
him
completely different.
Yeah, like a whole other person. That's for sure.
Wow.
If you don't know what we're talking about, just go to Josh's X account. That's where he posted it.
Oh, wow. Okay, I was completely wrong.
So it is
Rocky
Photoshopped.
is saying it's photoshopped. I don't know.
It's a good Photoshop. I really couldn't tell.
I can pull it. Just let me pull it up. Real quick. I'm so sorry to get sidetracked, but since we're not doing another live, hold on.
Yeah. Got a little more time.
What is? Do we follow?
Somebody said it's fake. It's him and CP's faces mixed together.
Oh, I have no idea. Is it on? What is Josh's? Hun, you're the ex person.
Yes.
I know, but do you follow him?
Yes.
Okay. That would be easier for me to.
So some people took it as a joke. Some people took it as real.
I looked at it and I couldn't tell.
A couple people said, no,
really
that's
didn't
him.
know.
It's not fake.
Well,
War
I mean,
Damn
how are
Eagle
we going to
said no.
know?
War Damn Eagle said, no, it's an old photo of him.
No way.
I wouldn't want any of my old photos up there. I can tell you that.
Okay, I'm going to share it.
Seriously, he could be master of disguise. Go back to that look. Nobody would.
I thought it was a joke,
it
too.
completely changes what he looks like.
I didn't look twice at it because I thought it wasn't real. Oh, my stars.
Yeah, I was definitely unsure.
Okay,
I didn't
so
know.
there it is.
Oh,
This is the controversial picture.
So you used to be a photographer,
that's not
right?
Chris's
So-
face put on top of his at all.
is there somebody
Rocky
in the chat
says,
said?
I have the original screenshot in the comments unless it got deleted. Oh, I don't know.
Okay, War Eagle's saying it's definitely from a live broadcast he did.
Well, I believe War
For how
Eagle-
many years ago? That's the question.
Or somebody else is saying that's not him.
No,
Well, it's
that's
gotta-
definitely him.
Well, I think.
I don't know.
Oh, this is Hannah. This is recently Hannah Kobayashi. That's recent.
Oh yeah.
So that's why I thought it wasn't.
Yeah, you might be right. Yeah, because we've seen him. Well, I don't know. if we've seen him.
Ginger Girl's mom said War Eagle is correct and wins the Crime Dog prize.
Well,
I don't know. I guess I'm still unsure.
I
'cause
guess we can just go to that.
Josh said, "Who's that?"
Is Josh just confusing us?
I don't know.
Who is he? I don't know.
Um,
I'm at a loss. I don't know.
well, I think what we've established though is that if SF does want to be in disguise, he can be, and nobody will know who he is.
Yeah.
So
No doubt. I'm still not sure.
I have no idea. Well, anyway, back to the case.
Yeah.
Okay, that was our break.
And I actually thought we'd have some clarity on it, but I'm actually more confused now. But yeah, so let's
I'm so confused. Yeah. All right. Well, back to the case. Sorry.
I think I'm at the top on this one. So I guess what this is each page has like notes. Is that how they're doing this? It's almost like footnotes for each page, kind of laying out different. Yeah. Okay. I don't think I have to read all that.
Rocky said she'll email you the original.
So yeah, I think.
Thank
on this,
you, Rocky. It's nice to see you.
I think the bigger font is what I need to focus on. So Anti-Slapp motions on February 18th, 2025, and having now reviewed all relevant submissions as well as the applicable sections of Pennsylvania's Uniform Public Expression Protections Act, it is hereby ordered and decreed that the anti-Slapp motions are granted for the reasons set forth herein. This case arises from alleged statements and or conduct of the defendants who host true crime podcasts on YouTube and moderate online discussions with members of the public through online chat rooms about news and or criminal investigations. In particular, the defendant podcasters, Granny's Watching and Barbecue Lady, have discussed the case.
Oh, sorry. I was trying.
Need a little attention.
You guys are gonna make me laugh. No, I was gonna go start making nighttime medicine. Sorry.
Yeah, I got you.
I was gonna turn on my thing and I forgot how to do it because it's been so long. Sorry.
But can you put the article back up?
Oh, did it go away when my camera left?
Yeah,
Yes.
quick intermission, back to the show.
What?
It was a quick intermission.
Okay,
That
yeah.
was a quick intermission.
It
Can you not find it?
It
I don't
says
know what it-
remove.
I know.
But-
Hold on one second. I'll fix it.
I bet. Oh, there it is.
All right. Now I'm going to go.
Yeah,
Yeah, there you go.
Says,
You got
"Look
it.
at me."
I hit the wrong button.
You hit
Oh.
solo layout.
All right.
I don't want to do lives. I don't, you know.
Anti-Slapp. Okay, so I haven't. All right, yeah. This is the one we're on. I think Anti-Slapp motions on. Oh no, we read that. Okay, so this case arises from alleged statements and/or conduct of the defendants who host. Oh, I read all that too. Okay, the father of the missing child is plaintiff Seth Rogers, who has coordinated with various individuals and entities, including but not limited to the other 9 plaintiffs in this case, all of whom are either a media company, a television personality, and various YouTube broadcasters and/or podcasters and/or online social media personalities, to attempt to find his son. And a sprawling and at times almost incomprehensible document, and over the course of 79 pages and 350 paragraphs, the complaint and the civil action suggests that various statements of the 2 named podcaster defendants and 50 unnamed Doe defendants made it on publicly accessible online YouTube platforms, which several of the plaintiffs themselves have accessed, and on which panels, live shows, or chat rooms plaintiffs and plaintiffs' counsel have participated, give rise to no fewer than 47 purported causes of action under various state and federal criminal and civil statutes and Pennsylvania common law. The complaint does not seek damages for the alleged wrongful conduct. Rather, it seeks to preclude defendants from hosting their podcasts and to enjoin various forms of speech and/or conduct. Indeed, at least one of the plaintiffs has stated expressly that he intended to file a lawsuit without regard to whether he would win, but solely to cause the defendants to incur fees in defending against see reply and further report. Okay, so they're referring to a text message. I'm actually going to file a civil suit against you and make you pay to defend it. Don't even care if I win. Screw filing a cease and dismissed. Waste of time. Stand by. I was done with you, but oh well. Emphasis added. Okay. Nick the Hat posting on a chat replay. We're not asking for money. If they end the nonsense Monday, this could be settled Tuesday. The YouTube broadcasters and/or podcasters, Barbecue Lady and Granny's Watching, do not dispute that they have discussed the search for the missing child during their shows. Indeed, all parties agree that, as summarized by the court during oral argument, Barbecue Lady and Granny's Watching host true crime podcasts that are broadcast on the internet. And on those podcasts, like any podcast, they take calls, they make comments, and they express opinions about crimes and investigators and incidents. NT at 6? I'm not sure what that means. By and through the motions before the court, however, sorry about the dogs there. Defendants assert that the topics about which they comment on their podcasts are from public sources, and as a result, the motions assert that the lawsuits have to be dismissed because what defendants engage in is publicly protected free speech, and that the purpose of the lawsuit is to chill the free speech. The anti-Slapp motions assert that this lawsuit is not only frivolous and baseless, but also a prime example of the type of lawsuit that the Pennsylvania legislature sought to deter by enacting. I might have skipped ahead. On July 2024, a statute whose express aim is to protect Pennsylvania citizens from strategic lawsuits against public participation. Defendants contend that through Pennsylvania's anti-Slapp statute, the legislature provided courts with authority to dismiss the lawsuits like the one at an early stage of the litigation to protect defendants from having to defend against meritless claims designed to chill their free speech. In other words, Pennsylvania's anti-Slapp statute, like other states' similar statutes, not only provides essential free speech protections, but also protects those exercising their constitutional rights from incurring fees and costs unnecessarily. In theory, the Pennsylvania anti-Slapp statute should deter such claims from being brought. It did not do so here, and therefore defendants in this case invoke the statute and assert in the anti-Slapp motions before the court that the complaint should be dismissed and they should be awarded their fees and costs in defending against the meritless claims to date. So that is essentially what the defense argument has been all along, was that that it was the stifling of their speech and that their point of view and all of that, and that the anti-Slapp is meant to defend against that. And so at this point, she's dismissed that complaint, and they will get, let's see, awarded their fees and costs in defending. So they'll get their attorney fees, and then probably whatever filing fees there are. Chief among the rights and liberties, and this is where she starts to get into the free speech aspect. Chief among the rights and liberties embodied in the United States Constitution is the freedom of expression. In the summer of 2024, Pennsylvania enacted the Pennsylvania Uniform Public Expressions Protection Act, the so-called Pennsylvania Anti-Slapp statute, to curb lawsuits brought primarily to chill the valid exercise of free speech and to encourage continued participation in matters of public significance. Based on the Uniform Law Commission and Uniform Public Expression Protection Act, Pennsylvania's anti-Slapp statute is designed to protect from baseless lawsuits those individuals who are engaged in constitutionally protected activities, such as speech or petitioning related to public participation. It does so by granting immunity in the form of substantive relief to parties who exercise their rights to protected public expression. The avenue for a defendant to invoke this immunity and secure the substantive, that's a tough word for me for some reason, relief afforded by the statute is a motion to dismiss made within 60 days of a complaint being filed. That asserts that the cause of action are based upon the movement's public expressions that are immune from suit. Pennsylvania's anti-Slapp statute provides for immunity in civil cases if either of the following applies: where the party asserting the cause of action based on public expression fails to, and then she's going to read into that. I got to have a sip of water. So the way I'm reading that is this judge clearly views this as an attempt that the public expression of the defendants was the reason they were trying to get the injunction, and not really the other items that were discussed. I think so. It seems to be her belief is that this was an attempt to chill free speech. So I don't know what this phrase means. I know so establish a prima facie. I don't know how you pronounce it. FACIE. What does that mean? I don't know. I know I've seen that word. I should have looked it up before.
Or what, prima facie or fascia?
Yeah. What is that? What does that mean?
Hang on, I'll tell you.
You see it all the time in these court documents. I should have looked it up before now.
I've heard it used before as well.
It's Latin for at first sight or in the face of it.
Established a prima facie.
Oh, okay. Adequate. It means that there's like adequate evidence.
At first glance,
that there's adequate evidence at first glance. Okay, so
sufficient evidence to proceed to trial or further investigation unless it's rebutted by stronger evidence.
Okay.
If someone is found with stolen goods shortly after a theft, that's prima facie evidence that they were involved.
Right. Okay. So the case as to each essential element of the cause or action, or state a cause of action upon which relief can be granted. Where there is no genuine issue as to any material fact and the person against whom the cause of action based on protected public expression has been asserted, it entitled to judgment as a matter of law in whole or in part. The statute defines protected public expression as communication in a legislative, executive, judicial, or administrative proceeding, communication on an issue under consideration or review in a legislative, executive, judicial, or administrative proceeding, or exercise on a matter of public concern, of the rights of freedom of speech or of the press, the right to assemble or petition, or the right to association guaranteed by the First Amendment to the Constitution of the United States, or Section 7 or 20 of Article 1 of the Constitution of Pennsylvania. All right. So then she says, based on the foregoing, the preliminary question raised by the anti-Slapp motions is whether defendants' YouTube podcasts are protected forms of public expression. If so, defendants are immune from the lawsuit. In the case, unless the court determines that the parties asserting the claims have either established a prima facie case, I hope I'm pronouncing it right, to each essential element of the asserted causes of action or stated cause of action upon which relief can be granted, The statute provides that in resolving motions such as the anti-SLAPP motions before the court shall consider the record as defined in its cites of law, the special motion and responses in the evidence which can be considered on a motion for summary judgment order. I'm not sure I absorbed that myself. Did you?
And I was doing chat, so
That's okay. All right, let's just see where it goes. Where a court grants the relief as requested in the anti-SLAPP motions, the statute is clear that the prevailing party is entitled to an award of attorney fees, court costs, and litigation expenses. Further, the Pennsylvania anti-SLAPP statute does not preclude an award of punitive damages. These provisions are an attempt not only to deter frivolous lawsuits aimed at silencing speech while ensuring that defendants are not financially burdened by defending meritless claims, but also to deter frivolous anti-SLAPP motions filed only to delay litigation. So, okay, so that sounds like you don't want this to go both ways. You don't want frivolous anti-SLAPPs or frivolous SLAPP suits in the first place.
right.
Defendants argue that their YouTube broadcast podcasts are protected speech as defined by Section 8340 of Pennsylvania's anti-SLAPP statute because the broadcast podcasts are activities that relate to a matter of public concern and implicate the right to freedom of speech that is guaranteed by the First Amendment to the Constitution of the United States. Speech deals with the matters of public concern when it can be fairly considered as relating to any matter of political, social, or other concern to the community, or when it is a subject of legitimate news interest. That is a subject of general interest and of value and concern to the public. And, I keep thinking too that this is the same defense that Bullhorn Betty will be giving. It's interesting, the parallels of it.
It really is. I have a hard time trying to figure out where the line should be drawn, because we've heard so many comments and accusations against people, and I wonder where that line is, like what you can say up to what point that it's not defamation or it's not something that can be sued for and won.
Yeah, I think. Yeah, I mean, we could talk.
There has to be a line. There has to be a line.
Sure. I think that I think the problem might be strategy-wise. There was too much included.
And yeah, and when you've got 7,000 pages, and I think there's a lot of question about, were all the exhibits there? Were the exhibits not brought forward first, and it's just the documents, and the exhibits aren't there until it's considered? There's a lot of questions about that I would like more information on.
Yeah, I mean, so some things weren't filed properly. But I don't think that's what her decision's based on. It looks like her decision's really based more on how she views the anti-SLAPP, right?
I just wonder if they viewed some of the videos and they felt like they had a good sampling to make that determination.
I know I felt like this when I was reading through all of it, where I would be at times saying, well, because there's so many allegations. Some of them were stronger than others. Right. And so sometimes I would be reading them. I was like, if I were reading that alone, I would go, that's protected speech. And then I'd get to another one. I'd say, well, no, that's kind of more in that line of defamation. So you kind of wondered, because of the massive nature of what they filed, what was going to stand out to the judge. Like, would they be more compelled by the stronger allegations, or more compelled by the the weaker ones? And it seems like, or the ones that in my view, were protected speech throughout. It kind of, because it was all mixed in, sort of.
And I think a more simple, possibly more simple and direct would be good.
I just spilled coffee on my shirt, so
that's why the change.
Yeah.
Or you just needing more attention.
I guess I need more attention. I don't know. No, here, I'll show you. I did.
I'm sorry.
I just didn't want to have coffee down my shirt.
Yeah. I'm sorry.
That's okay. I thought it was.
You're drinking coffee late.
I know. I thought we were doing another stream. So.
And well, we might be going late because I'm only 7 pages in.
Okay.
Been in the live. I don't know. An hour or
Hi,
two now.
Detroit Rock City. Welcome in.
Kathy made the point of, she said, respectfully, though, BHB is in court for an order of protection that was granted. I think that order of protection, though, is very similar to some of the things that they are being accused of in this, some of the statements and things like that. So you can see some parallels. We are fully aware of what she was in court for.
But it's going to be the same defense, because the argument she can make,
right,
is that the protective order was brought about in the first place to silence her speech, and not because of any actual fear of harm, and so it's the same argument in a lot of ways.
Yeah, I mean, she lives in Florida.
It's obviously not identical. It's just
she lives in Florida, and she's only been to Tennessee now because she's had to defend herself in court. So before that, she'd been there once.
Yeah,
so
it's not identical. It's not out. It's not. It's just similar. There are some similarities between the two, but they're not identical situations.
Kelsey
says, winning an anti-slap motion does not mean what the person said was true or ethical. It only means they had a legal right to say it under free speech laws. Yeah, I mean, in general, you're living in a country with free speech when the most despicable things can be said, or the most unpopular ideas can be voiced, and it's protected. But we do have laws that have lines on it. I mean, but
this is a misconception about Betty. It says Betty's ROs are based on her actions. The violations would be fought on free speech.
Right.
Well, it's a misconception because she essentially just talked about them on her show.
Yeah, and I'm not trying to get into that either, but I just
you can see the arguments could be similar.
Yeah, I don't. Yeah, it's just a similar. It's just there are some similarities between the two. Not identical, but they're similar. Let's see. I think we're at this paragraph. Plaintiff's untimely responses advance a series of questionable propositions with respect to the part of the analysis, urging the court to conclude that defendants are not immune from plaintiff's claims under Pennsylvania's anti-slap statute because defamation, harassment, and participation in a corrupt enterprise are not forms of protected speech under that statute. Okay. I had to reread that just to make sure I understood it. They suggest, for example, that the Pennsylvania anti-slap statute defines protected public expression narrowly, even though the statute expressly provides the contrary. Construction of this subchapter will implement the goals under paragraphs 2 and 3, encouraging participation in matters of public significance, not chilling such participation through abuse of the judicial process, granting immunity to parties exercising rights to protected public expression, and awarding attorney fees to parties forced to defend against meritless claims arising from the exercising of their rights to protected public expression. Emphasis added. Plaintiffs state further, tellingly without citation, that the Pennsylvania anti-slap statute explicitly excludes defamatory statements, harassment, and malicious conduct when the statute does no such thing. Similarly, plaintiffs see the defendant's alleged statements fall outside the scope of the statute's narrow definition of protected public expression. Based on Wecht versus Rhodey, a case that preceded the enactment of the Pennsylvania's anti-slap statute by 24 years and therefore cannot support such a proposition. So this is kind of where you get into a little bit of just how a judge is going to determine which holds more weight. Yeah. So I mean that's just okay. That's interesting. Plaintiff's response to which one is that? Which one's Sing?
Sing is GW.
Okay. Response to the Granny's watching motion makes similarly unavailing arguments. For example, in arguing that defendant's conduct does not qualify as protected public expression, private nature of defendant's conduct. Okay, so they cite a number of laws here as support for the proposition that Pennsylvania's anti-SLAPP statute does not protect knowingly false statements or conduct motivated by malice. But that case does not involve the Pennsylvania anti-SLAPP statute or any anti-SLAPP statute, so it could not stand for that proposition. Likewise, plaintiffs argue that Philadelphia, another case, but again, that is impossible because the case does not involve the Pennsylvania anti-SLAPP statute or any anti-SLAPP statute. So it's like any law they're citing. She's kind of just saying, well, that it's null because, or precedent is null because of the anti-SLAPP being more recent. I don't know, but that's her decision. Beyond the,
excuse me, sorry.
Bless you.
This lady, she's got a vocabulary. Beyond the inapposite, I don't think I've ever seen that word before. Case law, moreover, plaintiffs cannot credibly claim that the search for a missing child, for which they themselves have coordinated extensive efforts publicly, as described throughout the complaint, is not a matter of public significance. Moreover, plaintiff's response to the Granny's Watching motion admits that Granny hosted a podcast discussing true crime and that the podcast involves calls and chat communications and discusses national news and trending cases. Okay.
Could I just
that word means not relevant or not appropriate.
Okay, so beyond the inappropriate case law.
I'm not I just want to go back to chat. We're not going to argue with each other. Please be respectful. And I want to tell you, I think you're misinformed about, she said, no one stalked Betty. She videotaped her doing everything. Wasn't very smart.
Man.
I think that if you went back and watched that day that Betty was there, that's in question, you would be very surprised by what you see.
I watched it live, and I was watching it live when she was actually being followed and stalked by someone in that family.
And we did watch it live,
and I know what my eyes saw.
So I just would prefer, you're welcome to your opinion. Just there's no reason to keep going back and forth about it. Most people in this chat all agree about that. We all saw it live. So
yeah, go watch the 30 minutes leading up to it. She's in,
yeah,
she moves the car a little bit. She's in the same area. We kind of have an advantage because we know that parking lot. She was in the same place for basically a half hour.
No, I didn't know that, Tiff. That's interesting.
You can't really stalk anybody when you haven't moved for a half hour.
I didn't know that. That's interesting. So there's no reason to go back and forth and chat about it, is what I'm trying to say. I would recommend going back to that day and watching it. We know for a fact that she was not stalking anybody.
There are some cleverly edited videos out there, so that might be what you've seen. But if you go watch, if you want the truth, go watch the original live and start about 30 minutes before she has that interaction, and you'll see that she couldn't possibly have been following anyone because she was talking to a police officer for like 15 minutes right before that happened. She moves her car a little bit, but she was in the same, it was basically it was really close to Texas Roadhouse. She was there talking to the police officer, and that's when he rolled up behind her. But you just go back and watch it if you care, if you want to know.
Okay. And I'm going to ask you respectfully one more time to stop arguing about it, because
she was doing a live stream talking about putting up signs. She was not following him around. She had been live for quite some time, so we could see what she was doing, and she was talking to the camera. She wasn't following him at a store that was far away from where she was sitting.
And receipts, I don't know this, but receipts can be fabricated. Okay, so just keep that in mind. We don't know where that receipt came from. We can't confirm it.
Yeah, and knew he was going to pull up behind her.
Yeah.
If you know the parking lot, you don't exit that way. like I said, we have a little bit of an advantage because we know that parking lot, but you don't leave.
The way that that's not how you leave.
You can't exit. You don't exit that way unless you're going out of your way to swing up to that area.
Well,
that's not the exit.
Right, that's going toward the store, not away from the store.
Looped. He would have had to have looped to get to where he was, because that's not how you get out. There's only like 2 ways out of that giant parking lot.
Yes, it was going towards the store, not out
for him to
toward
go
the parking
toward
lot.
He was going toward basically a dead end, which is the Texas Roadhouse direction, which you can't get out without passing back. Anyway, it's just hard if you haven't actually seen it. But yeah,
but we're there all the time.
Yeah.
So.
But that's not why.
Ginger Girl's mom says she's a little confused. This seems to only address words that were spoken and not behaviors that were done. And she said, "Am I wrong?"
Okay, I'm gonna say this one more time. There's a lot of people here that aren't normally here, and you're saying rude things. You are going to get blocked. We're not doing it. So,
yeah, well, I mean, I think we're being as fair as possible to everybody. We're trying to be.
There's one for you. So, you know what I mean? There's there's a bunch of rudeness trying to imply that
I don't even want to highlight.
I know what I mean. What I'm saying is I'm not going to play anymore with this.
Yeah,
I'm tired of it.
Just block them and don't look back.
You got it.
I mean, I think we're being about as fair as we can. We're just trying to understand what happened here. And if people want, I don't even want to talk about anything.
Like you said,
I just want to.
People are being intellectually honest, then that's fine. But just complaining is not gonna cut it. Go ahead.
Yeah, I know that. Yeah, I know they're doing it on purpose. They admit further that news outlets and social media platforms discuss the disappearance of Mr. Rogers' missing child, and the defendant's podcast includes an open panel feature. They further and fully acknowledge the plaintiffs Atnight and Nick the Hat and others involved in their effort have coordinated media outreach and have made public statements about their investigation and the lawsuit, including but not limited to hosting a press conference and conducting a live stream podcast or broadcast about the matter. Thus, it is simply not credible to argue that the defendant's statements conduct, as alleged by the plaintiffs themselves, do not fall within the scope of the Pennsylvania Anti-Slapp statute that provides immunities from suit for protected public expression. To be clear, the First Amendment to the United States Constitution states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government to a redress of grievances. While freedom of speech is a cherished right, the right's not absolute at all times and under all circumstances, and thus can be regulated. Regulation of a person's freedom of speech may occur if the speech would inflict a harm or is a true threat, or if such speech has been deemed unacceptable. All right, so citing several case law there.
This was an interesting comment by Rosebud. She said, even though the laws are written, I sometimes wonder, since it's so cut and dry, that the courts reference some of their own beliefs in what it interprets. Society has changed, but the Constitution is the same. And that's very true.
Absolutely. It's why, if you go to the Supreme Court, you've got, arguably the 9 brightest judicial minds in the country, and they never agree on anything hardly.
It's always a split.
5-4. And not always just because of political party. It matters who you get as a judge, and you get a different judge, you might have a different outcome. And if they choose to appeal, they might get a different outcome. You just don't know. That's why I had always been kind of suggesting to everyone, if you can, negotiate and come to something where you don't get into the whole 5-6 months of litigation and going to courts and all of that. If you can find something that you can live with, you should try to do that first. And that's my advice to everybody every time, because once you get in a courtroom, you just don't know what's going to happen. It could have gone a lot of ways. You just really never know. Let's see. So here we have, so they cite all the case law. A thorough review of the complaint in this case leads the court to conclude that plaintiffs have not alleged any speech by any of the defendants from which the court could conclude that defendants' words would inflict a harm, are a true threat, or have been deemed unacceptable. Notably, plaintiffs did not even attempt to so argue in their untimely responses to the anti-SLAPP motions. So I think that's part of it. The untimely responses, the not filing properly, things like that. Because she mentions it a few times. At oral argument, moreover, when pressed to tell the court why what the defendants are doing, hosting true crime podcasts with topics culled from public sources, why that's not publicly protected free speech. Plaintiffs offered the following. Oh, I see. Because it goes a step further. During these podcasts, they made accusations of Seth Rogers being a P word. This is more than passing a note to the person next to me. This is more than me espousing it in a court document. What we have is going beyond name calling and sarcasm. We have people who are espousing to thousands of viewers in these podcasts all over the world, all over the country, who are then coming back and causing damage, irreparable damage to Mr. Mathis, who's helping Seth Rogers in the finding of his child. And these podcasts are getting in the way of him doing that because they are labeling him, and they have labeled him and accused him of being the offender. They've accused him of being a molester. This argument does not advance the ball for plaintiffs for at least three reasons. First, they appear to suggest that by making statements in a form that is accessible all over the world changes the analysis. The court is aware of no authority, nor do plaintiffs provide any, that would support the conclusion that there is a different framework for assessing speech when made during a public podcast, particularly one on which public plaintiffs themselves are communicating. Second, plaintiffs' argument seems to be that unnamed others who listen to defendants' podcasts are the persons who are causing harm to the plaintiffs, or some of them, Mr. Mathis and Mr. Rogers. There is nothing in the complaint that provides any specific information of how defendants are causing others to act and their alleged accusations. No information as to which of the defendants made the statements, no information as to who the unnamed others are or how the others harm themselves. Third, the only time the entire complaint, the plaintiffs allege defendants to have made accusations related to the P word is in the count for intentional infliction of emotional distress, not defamation, asserted on behalf of plaintiff Rogers. As alleged, and even when viewed through the lens of a claim for defamation, the single alleged accusation that one of the... it's not moving for me for some reason. This is frozen for me. I don't know why. Is it frozen for you?
I was able to move it to 11.
Okay.
Let's see.
I need a water break anyway.
That's okay. Let's see. I saw a good comment. And actually, dreaming of blue skies and sandy beaches, I just saw the Cash App. Thank you so much. That was very kind of you.
Thank you, Dreaming. We appreciate it.
Rosebud always has the best comments.
Oh, yeah. Rosebud says, again, I can read the same thing as my neighbor, but interpret it differently. I feel this is what is happening with free speech. Yeah, it's so hard. I mean, it's a difficult. It will be a, we'll always have these discussions about speech. I think it's interesting where that line is, and she certainly is a free speech advocate. Just reading this,
well, a true crime junkie had a good point. She said, "I'm just confused as to why Atnight and the lawyers chose to call it a RICO and not go about it in a different way." And I think there could have been several different ways that they took this on. All we've done is kind of just read what we have found out about it. But yeah, I think you could analyze the way it was handled and decide maybe a different route would have been more successful.
Yeah, I mean, I'm sure everybody could. I'm sure everybody's sort of Monday morning quarterback, rethinking what would have been a better strategy, what could have worked, but see what, again, on this particular judge, this was not effective, but maybe it done a different courtroom. You never know. But yeah, I kind of feel that way. Maybe a narrower approach.
Can I stop you for a
Yes.
second? We have 421 likes. If we get to 500, can we do machete?
Sure.
Okay.
Sure.
We're close.
Yeah, we'll do the machete party.
Well, okay, so if we can
Just
get up,
because we've missed it, and if you're new to us, I think it'll be worth it to you. I don't know where I was.
you starting on page 11?
Oh, I'm just starting at the top, right?
Because you said it was frozen. Remember?
Yeah, and if you want to just stop me at any point, if there's any comments you want to do, just highlight them.
I think the food's already starting to cloud your brain up again.
Do you think so?
I'm just kidding.
I'm actually hungry again.
I know. I got really hungry this afternoon.
I know. I'm like wanting to make up for lost time during this
No.
72 hours.
And E, don't worry about modding too much. I'm fine. Why don't you just enjoy the show?
Okay, I'm just trying to stay on top of things.
Well, you can see it in the StreamYard.
Yes, but I've got it bigger so that I can read the document as well. And so when I do that, I can't see my chat.
Oh, I gotcha.
Because I got it blown up. I like to follow along with Mr. E's reading.
Yeah, I kind of think this is kind of a, where'd it go? Oh, there's something wrong with my mouse, I think. I can't highlight anything. Well, anyway, Tiff says, I think the filing was too convoluted. That's
a good way to put it.
That's why I kind of wondered, like, when a judge sees this and you first get it, what's their first impression of it? How did it land with the judge? And, did they think, oh, wow, this is massive? What did they read first? What stuck out to them? And it was complicated for sure. And
War Eagle says, in my opinion, this was a battle and we are in a war. Big picture, people. Interesting.
Yeah.
I mean, I think that's,
if we get through, I know I keep stopping to talk or whatever too, but if we get through, we'll talk a little bit about kind of what it means going forward, I think. And ultimately, this was what kind of will happen after this is things sort of go back just the way they are. I mean, nothing really changes much other than the obviously the victory for the defendants in that, they they go back to prior to the injunction being filed in the first place.
Kelsey says Just Irish hasn't seen the machete party.
You haven't? Okay, we got to get
to that. So
let's do the 500. If you're coming in, please hit that like button, and we'll have our machete party.
And Rob wants to know: do we know if it's being appealed? I've heard from other creators that it's being appealed, but we have not reached out to anyone for comment.
I think Atnight posted that they were looking at an appeal.
Oh, is it on X?
I think there was an X post about it.
Well,
yesterday
I haven't been active on X. He took over the account, and I haven't been looking at it. So,
but
but I have seen other creators mention it.
That's the kind of thing this is actually a question. I don't know if anybody will know this, but when you have that many plaintiffs all together, do they all have to agree to appeal? Like, how does that work? Does Atnight lead it? Whoever did the filing, or
I do not know.
Or do you have to vote? Or
that's a great question.
Can you drop out if you don't want to do the appeal? Because there's risks and reward for doing it. So I don't know. I don't know if anybody knows the answer to that. It was something I was thinking about today. Plaintiffs is a P word, does not take the speech out of the scope of protected public speech because of the suggestion. Does someone have the answer?
No, TN Nurse is here, and I just wanted to tell her hello.
Oh, well, we did it 5 minutes before we went live, TN Nurse.
Gosh.
I know. I know. We give like no notice at all.
Hi, Reality Win says, I heard they are appealing.
Okay.
Atnight said they are appealing. Okay. See, I really have not had time right now. My work has been very busy.
We've been super busy.
And Graham's here. We love Graham. Hey, everyone. Hope you're doing well. I finally get to catch a live. Well, we're happy you're here.
Good to see you, Graham. One of our favorites.
He's a mod, too.
I didn't realize Graham was a mod.
He's been a mod for a long time.
I know.
You're so funny.
I'm sure.
And I added Liz Blessings. I don't know if she approves of it or not, but I went ahead and just added her.
I thought we'd added her before.
I don't know. I mean, we did. She was here all during Megan Boswell. Probably should have.
Yeah. She was like our fourth commentary.
Right. And astrology
was?
for mystics,
Who was our fourth?
Bliss Blessings. She
Oh.
might have well been on the panel.
Yeah, during the Megan
Oh,
Boswell
yeah,
trial.
yeah.
We had
And
some
then-
great people that hung in with us.
Yeah, that was great.
And astrology for mystics with Jen, I added because we know her in person. We met her in person.
Oh, yes.
So,
Yes.
and she's a very
Oh,
nice
she was
person.
great. Yeah, I talked to her a lot. Yeah, they were a great couple. In light of the foregoing, the court concludes that the defendant's YouTube broadcast podcasts fall well within the freedom of speech protectorate afforded by the First Amendment to the U.S. Constitution. Moreover, defendant's speech on their YouTube podcast can be fairly considered as relating to a matter of concern to the community, the search for a missing child, and or are subjects of legitimate news interest, subjects of general interest and of value and concern to the public. In light of those conclusions, the defendants are immune from civil liability under Pennsylvania's anti-Slapp statute unless the materials in the record before the court establish that plaintiff's complaint sets forth a prima facie case as to each essential element of the causes of action alleged. So each essential element of the cause, okay. Or that the complaint states a cause of action upon which relief can be granted. Okay. Defendants argue that plaintiffs have not, through the complaint, established a prima facie case as to each essential element of the causes of action against the defendants or stated a cause of action upon which relief can be granted, and that many of the purported counts in the complaint are not actionable in the civil case, and this should be dismissed as a matter of law. Defendants argue further that the complaint on its face supports the conclusion that it was brought for an improper purpose. Okay, so that goes to the motive, essentially, right?
Audacity mentioned this, and I've heard this. I don't know where I heard it.
I have heard this somewhere too. In order to appeal, they have to put down a bond. So if they lose the appeal, the defendants are guaranteed their money to be reimbursed. Yeah.
That's fair.
Right. Rather than, where you have to try to collect it over years or ever, sometimes.
Mm-hmm.
Yeah. So there's risk. And then appeals are just expensive.
Mm-hmm.
They can go on a long time.
They can go on years.
Yeah. Defendants argue that plaintiffs. Oh, I think I've already read that one. Plaintiff's untimely response to defendant Barbecue Lady's motion. I don't know why I cannot keep it straight. Barbecue Lady's motion declares that they have established a prima facie case for the claims of defamation, harassment, and violation of the Corrupt Organizations Act through sworn declarations and exhibits. Hi, Girl Mom. Good to see you. Yes, some defendants can make a motion to sever or be removed for an appeal. Oh, okay. So yeah, like let's say somebody doesn't want to risk or take the costs or whatever, or they just want to be done with, they could be removed.
Just pay. Do they just pay their part, or how does that work?
I don't know.
That's interesting, right?
Yeah.
I
don't know.
Boho Girl said this was not a RICO case, and I wondered how you wanted to, because that's a common misconception I keep hearing, so that's why I was.
It's a civil. It was a civil. Well, the definition. It was a civil. It was an injunctive. It was as a request for injunctive relief,
right?
For an upcoming civil RICO lawsuit. Am I saying it right?
A lot of jargon.
So that essentially so it wasn't a criminal case. It was a civil complaint with allegations of
RICO,
violations of the RICO Act within it.
Yes.
Alleged actions. Yes.
It's convoluted. Yeah. It's difficult to understand.
Trying to think, I was reading about it somewhere a few months ago, just trying to learn about how these civil RICO things work. And in some places, so if you feel you've been civil, that you're a victim of a corrupt organization, and you can't, let's say it's hurt your business. Okay. Like just, it's hurt your business in some way. You own a shop or whatever. And they've this group or organization has been damaging your business. Then what you can do to defend yourself, rather than try to sue each member of the gang or group or whatever that's working against you, you can file a civil RICO based lawsuit. That way you can do a blanket lawsuit against them, right? That's kind of the idea. And then like, then you can recoup your damages from the group, and then that's how you get relief. That's kind of the idea. I'm probably not saying it in the.
No, I think you're doing a good job. I see that Chronicles of the Shady has come by to visit. Welcome.
Hi, Chronicles of the Shady. Good to see you. Would you mind to? There's something wrong with my mouse. Would you mind to change the page for me?
Oh, absolutely.
I don't know why it won't let me do it.
If you refresh, it'll knock our mics off. So I'll have to be the one to do it. It's probably you might be able to go down and come back up, but I'll be silent for a second if you want to take yourself off.
Okay. Over here, just remove. Yeah, it won't even let me do that.
Okay, that's bizarre.
Yeah, I don't know.
Okay, well, I'll turn the page for you. Sorry.
Sorry. So 12 would be good. And Just Girl Mom was asking, was this civil or criminal? And this was a civil action.
This was a civil action.
The worry, if you were the defendant, is that if it went forward and escalated and the plaintiffs ultimately won, that it could become criminal if the prosecutors in those jurisdictions felt compelled to carry the ball and do it. And that they have provided declarations and otherwise met the elements of crime for defamation, harassment, and corrupt organizations. Notably, plaintiffs' untimely response to defendant Granny's watching motions declares that they have established a prima facie case for the claims of defamation, harassment, intentional infliction of emotional distress, and mischaracterization of settlement discussions. Yet plaintiff's memorandum in response to the Granny's watching motion asserts inconsistently that they have established a prima facie case for each claim, but then addresses only the purported claim for defamation, and again refers to various declarations that are nowhere in the record before the court. As noted elsewhere herein, the complaint references many exhibits but does not actually include any, nor were any ever submitted.
This is where I read, and it makes it sound like those exhibits were not included. You read that again.
Yeah, I think that's what that's saying. The complaint references many exhibits but does not actually include any, nor were any ever submitted via Precipe after the plaintiffs initiated the lawsuit and on October 2024 or at any reasonable time thereafter. Nor did plaintiffs attach any such declaration or any relevant exhibits to their untimely responses to the anti-Slapp motions in February 2025, and only attempted to expand the record of oral argument on the anti-Slapp motions 4 months after they filed their complaint. Thus, statements such as plaintiffs have provided substantial evidence supporting their claims, including declarations and documented social media evidence,
are patently incorrect.
Are patently incorrect, as plaintiffs have done no such thing. Do you mind to change the page for me there?
So that's where I read that, and I was like, I was really confused because it sounds like there were no exhibits.
Yeah, but didn't we?
I mean,
we read what they were, but I don't know that we looked at or we had access to the individual exhibits.
Well, we saw what was posted of the exhibits, right? Online.
Yeah. Okay.
I think that we didn't even try to, look at the exhibits because it was 7,000 pages.
Yeah. So people are saying that they didn't attach the exhibits. So,
well,
that was my understanding when reading this.
Yeah. So overall,
I thought it, but my understanding is that the exhibits were all printed. That was my understanding.
Yeah.
Blessed Mom said she couldn't find exhibits for one file, not even one of the filings.
The exhibits for the filings, they don't put I don't believe they put them, at least the Delco site I see. I don't know that I've ever seen exhibits. I might be wrong. I would have to go back and look. It's been so long. We've been doing this so long. I don't remember.
War Damn Eagle says, hang on just a second. I'll pull up what she said. Here it is.
I don't see exhibits.
I believe the original exhibits for the filing were not attached to the filing and were late being submitted.
Oh, well, that makes sense. Okay.
Yeah.
Okay. Overall, Plaintiff's responses to the anti-SLAPP motions are as unhelpful to the court's resolution thereof as the complaint, but for different reasons. Put differently, plaintiff's untimely responses are as anemic as their complaint is verbose. As noted, the response is not only. Anybody change the page for me?
Sorry.
Well, I am actually going. This is going much longer than I would have thought.
Yeah, I'm glad
I'm only
that
on page 14. Yeah, there's no way we could have done it.
I really
We would have been going into the wee hours of the morning.
Yeah, I know.
we really thought that we would be able to get through this like in an hour. We were wrong.
Refer to the exhibits not in the record, but also simply make summary statements without any analysis that the defendant's conduct does not fall within the scope of protection afforded by Pennsylvania's anti-SLAPP statute, and that plaintiffs have established a prima facie case for each claim. Surprisingly, given the length and breadth of the complaint's wild allegations and its 47 supposed counts, the response to the anti-SLAPP motions contained no reference whatsoever to any of these allegations and no analysis of how any of those allegations establish any prima facie claim, whether with respect to the 47 counts in the complaint or even just the 4 claims that the responses state flatly have been established. Put differently, plaintiffs' responses to the anti-SLAPP motions are not presented in a manner that helps the court discern which portions of the record actually establish a prima facie case as to each essential element of the causes of action purported to have been stated in the complaint, or which portions of the record, or even just which allegations in the complaint would allow the court to conclude that plaintiffs have stated a cause of action upon which relief can be granted. Moreover, and particularly important in light of the stated purposes of the Pennsylvania anti-SLAPP statute, plaintiffs' unwieldy, and cumbersome complaint prevents defendants from discerning the salient facts and civil torts that they have supposedly violated, thus rendering the defense of such a lawsuit even more difficult and costly than a lawsuit that is drafted with directness and clarity.
She's basically telling them how they should have done this and saying this should have been direct and clear and not cumbersome the way it is, that it's too much information, which kills their case, basically.
Yeah. Organization.
Mm-hmm.
Although the court has attempted to decipher the complaint, the court notes that plaintiffs' untimely, paltry responses to the anti-SLAPP motions fall far short of demonstrating that the immunity afforded by Pennsylvania, she's annoyed with it too.
Yeah, you can tell. You can hear it in her voice.
Yeah. That the immunity afforded by Pennsylvania's do you mind to change the page for me?
No, I don't mind.
SLAPP statute does not apply in this instance, or that plaintiffs have properly pled or supported any viable cause of action against the defendants. Although the court could grant the anti-SLAPP motions on the basis of the foregoing alone, including but not limited to plaintiffs' failure to point to any allegations or evidence that demonstrates any viable cause of action against the defendants, the court has endeavored to examine the complaint to discern whether there is any basis for plaintiffs to overcome the immunity afforded defendants by plaintiffs' anti-SLAPP statute. As noted elsewhere, this effort was made difficult by the sprawling behemoth that is the largely unverified complaint. Indeed, the civil complaint is a rambling and disorganized document that reads more like a salacious tabloid peppered with references to an undefined enterprise and a host of criminal Pennsylvania and federal statutes that defendants are accused of violating. In 350 paragraphs, the complaint identifies 10 plaintiffs, although only 8 of them purport to assert any counts against the defendants. I think that the Taco family dropped out, right? For some reason.
I don't know. I think somebody dropped out.
I think that's what happened.
Or were removed.
Or were removed, one or the other. So that's why that alleges various facts, including a brief background.
That's a good point, Sharon.
The higher the court, the more scrutiny of the case. Much more time will be spent looking at the exhibits. They have lots of interns to help. Just my thoughts.
No, you're right.
So I don't know how this works with appeals. Can you actually reorganize if, and
I mean, I think we're all kind of learning this stuff in real time. At least we are.
I know you can also do a motion to reconsider. That's also done in cases such as these. I've seen that
done
before.
in a Commonwealth, though?
Yes,
Okay.
it can be. It can be a motion to reconsider, or it can be an appeal.
Well, when we get to the end, she's going to say that it's, I think, dismissed with prejudice, I believe is what she says. So
spoiler alert.
I know I ruined it for everybody. I'm so sorry. I don't know. Does that I don't know. Does that stop that ability? I wonder.
I don't know.
I don't know.
Hi, perfectly imperfect boy mom. I got it out right without tongue twisting. Welcome in. And Just Irish became a member. Well, thank you, Just Irish. I know we got off to a bumpy start, but we appreciate you. And we're happy that you're here.
Yeah, we're glad to have you.
Somebody, this is funny, a funny comment. Hang on. It was from, let me see if I can find his name. It was from Ronnie G. It was pretty, oh, here it is. He said, yeah, this filing was so egregiously bad, it brought me over from the Lawtube community. So they just felt, the filing was very cumbersome. I thought that was interesting.
Okay. I'm unfamiliar with the Lawtube community.
You know what? There's all kinds.
Yeah, there are all kinds.
There's probably an underwater basket weaving community that we're unaware of too. So I think there's all kinds of different communities. So.
Oh, sure.
And I believe it was Bullhorn Betty that told us the knitting community is like worse than true crime. So, if you can imagine,
I remember. I'll never forget her saying that actually, because it was. She's like, "Oh, it's way worse than true crime." It can't be right. But I guess the knitting is huge.
I'll have to check out Lawtube. That sounds like fun.
Mm-hmm. LA says Lawtube is an awesome community.
Tiff says there's a knitting community I knew nothing about. Apparently, you need to stay away.
We heard it's cutthroat over in the knitting community.
A bunch of drama over there with that knitting community.
That's what we've heard. It's not even a joke.
It's not a joke. It's not. She was very serious about it.
We're only at 468, guys. If you want to do the machete party, we'll have to get to 500. He's pretty strict about those rules.
Let's see.
468's all we got, so we got to get some more.
LA said, okay. I watched lots during Adept versus Herd. Yeah, that the bits and pieces I've seen of that it's a very interesting case.
Well, who are some decent Lawtube?
Yeah,
people
give us
to
some
see?
suggestions.
You've got some people that we should check out.
Yeah,
on
put them in
Lawtube.
chat.
I'd be interested. I mean, I love learning about this stuff. The knitting folks get riled up over patterns and everything. Amazing. It's amazing. It should probably not be surprising, but it is sort of. I don't know where I was. Did I finish this page?
Oh, stars. Gender Girl's mom says the quilters are competitive as well.
Oh, I bet.
What?
But how do the quilters feel about the knitters? Are they good with each other? Is there like a no?
I don't know. They may have some. It might be like the Bloods and the Crips.
It's crazy. I think we finished this page. Yeah. Word Eagle says, I hear there is even more drama in the knitting community, believe it or not.
Wow.
Yeah.
That's amazing. Okay. Zelda says Emily Baker is amazing. Lawyer Lee, Harvard lawyer. A lot of Emily Bakers. Law and Lumber. No, that's awesome. Let's see.
Okay, Emily Baker.
Somebody said you have to watch out about the knitting community because they have sharp weapons.
I'm going to write them down because I want to check a few of these out. So Emily Baker, and somebody's saying DUI guys.
Oh, DUI guys. Yeah.
I'll tell you, just while he's writing those down, in our family, and Aunt E knows this because she came to visit, and Granny kind of got over it. I'll just tell you.
Runkle of the Bailey.
Ooh. Interesting.
Law and Lumber.
I missed what you just said.
I was just, this is the same discussion we had earlier about you not listening to me when I talk.
Yeah.
We had a discussion offline about that.
Yeah.
Anyway, what was I? Oh, so when Aunt E was here and Granny was here, they got to have a taste of what we watch.
Oh, yeah.
For fun.
Yeah.
For recreation. And I think Granny got really tired of it. But we enjoy watching people get arrested for shoplifting at Walmart or Target.
It's fun for the whole family.
Well, when I went over to
enjoy
my daughter's to visit, while I was there visiting you guys, and I went over to her house one night. I come in and they're watching Cops, and so they're watching the same thing essentially.
Yeah, there's Lily loves to see people get justice.
She's
She cracks me up.
She's a don't break a rule kind of girl,
Yes.
and so it pleases her to see people get justice.
And she cracks up. She laughs.
Oh, she thinks the tasing, when people get tased, that is everybody's favorite.
Grammy says Lawyer is awesome.
Lawyer
Okay.
Oh, I like that
Yeah.
name. Yeah, so that's kind of been our thing, is we enjoy watching people tell the stories about that they didn't shoplift, and Target is especially entertaining for some
Yeah.
reason. I don't know why, but Target is
Target ones
especially.
And then
good.
we were at Target and saw somebody get swept into like the room where we know they do the arrest.
We were so excited.
Yeah, all the kids were thrilled. They were like, "Oh, stop resisting, because that's what they always.
They always say
Always
stop
say that.
resisting.
So the kids were having a blast seeing that.
We
Because
have,
now they know where the secret room is at Target because we've watched so many of those.
the kids know where all the secret rooms are
Yeah,
now.
they know where all the secret rooms are.
And Tiffany, we watch on actually pre C19 all the time. He used to watch On Patrol live.
Oh,
He
yeah,
loved it.
Yeah.
And we kind of watch it here and there, but for some reason, when we found that we can like focus right in on the 5 dumbest shoplifters at Target,
Right.
we tend to just kind of take our time to
that's-
watch that.
that's
That's our
good.
recreation
It's our
right now.
kind of
The law of self-defense is another good one. And they said any constitutional lawyers are usually the best. And that one was
Ooh.
law of self-defense.
I think we're going to be watching some new stuff.
yeah.
Because you
Well,
know how much
I
I
do-
love the Constitution.
I do appreciate the recommendations.
Yes, thank you guys so much. That's very sweet.
And if you want to watch the shoplifter stuff, Hidden Files is pretty good.
Yes, Hidden Files.
That's the one we like.
You have to get over the fact, though, that the guy seems like he might be AI at first. I think he's just, I don't know. I think he's portraying a role. He's got a great voice.
He does.
It's just awkward, but
He kind of just turns his head a certain way.
This is a good one. Did y'all see the Target one that the lady said Target owed her reparations?
yes, I did.
Yes.
I think I've seen all of them.
Yes. Yeah.
All right,
Some of those
that's
at Target.
funny.
I don't know why the Target ones are always the best, but they're always really good.
And
Law of self-defense is a good one. Okay.
also the Lawyer is hot. So if anybody wants to watch a hot lawyer, he's supposedly pretty hot.
Well, I don't know who that is, but
He is the Lawyer But somebody said all of them are good that's been mentioned, but Emily D. Baker is the best.
oh,
Okay.
Emily D. Baker.
I will
So
check
put
it
a
out.
star by her, and then just for good measure, the Lawyer
Okay. Should we stay out of their chats? Is it another is it like the knitting community over there? Or should we tread cautiously if we go visit?
knit 1, pearl 2. No, no. Okay,
Is
it's
that one of
really
our
sad tonight because we only have 482.
Oh, we
we
can
are
get
so
there.
close yet so far away.
Okay, I think we're ready for the next page.
Okay,
Yeah, let me take that down so we can see it.
hold on one second. All right.
Fourth, various counts on behalf of some, but not all of the plaintiffs. Simply put, the complaint in the case nearly impedes judicial review because it is poorly pled and lacks a coherent and logical presentation of the material facts on which the causes of action are based in a concise and summary form. Yeah, it was massive. So I can see.
I can see
How
why
it was
they would be
difficult
angry
to
at it.
understand. And plus, we also have an advantage. We know the people, most of them. I mean, I don't know all of them.
I think that's part of
And
what
it-
makes
we-
it fascinating.
We knew some of the things that had happened, but not all. So we kind of have we already kind of have a preview. And for a judge, they don't know any of these people. They don't know, they're seeing all of it for the first time, all these names, and it's just hard to. I would be overwhelmed as a judge. So I think it makes it difficult for them to step into it, just in a practical way. Pennsylvania is a fact pleading state and it requires a greater degree of particularity and organization than the complaint in this case provides. Requires that the material facts on which a cause of action is based shall be stated in a concise and summary form to enable the adverse party to prepare her defense. If anything, the complaint reads more like a pleading that the scrivener intended to file in a criminal proceeding, as it refers throughout and consistently to criminal statutes. But even viewed through such a lens, the meandering presentation of the facts supporting supposed violations of the law is almost incomprehensible. Indeed, by appearance and substance, the complaint does not seem to have been prepared by a practitioner with more than 20 years of litigation experience. Would you mind to do the page for me?
Sorry, I'm trying to keep up with chat.
Moreover, although the complaint references well over 50 exhibits, absolutely no exhibits were attached to the pleading filed on October 18th. The court acknowledges that during oral argument on the anti-Slapp motions, plaintiff's counsel informed the court that he has not been permitted to upload videos, podcasts, or the YouTube broadcast to the Office of Judicial Support docket. However, the court notes that nothing prevented plaintiffs from uploading to the docket the 46 documents that are referenced in the complaint, which are clearly paper exhibits. For example, all of the sworn declarations of plaintiffs. Similarly, nothing prevented plaintiffs from filing the reference exhibits via praecipe. They did not. The docket contains no such praecipe, and it was only at oral argument on February 18th, 4 months after they had filed the complaint, that they proposed that the court should accept the omitted exhibits and audio transcripts of the YouTube videos, podcasts, and or broadcasts. Likewise, plaintiffs could have, but elected not to, submit transcripts for the hundreds of hours of these YouTube podcasts, from which the plaintiffs argued at oral argument their claims against defendants arise. Notably, and pertinent to the court's analysis of plaintiffs' purported civil claims against defendants, the filed complaint makes only general references to the YouTube broadcast podcast with no specific identification of the date or time of the purported statements that are the basis for the purported claims against the defendants. Moreover, the very few specific quotations that plaintiffs attribute to each defendant are set forth without specificity as to the date or time that these statements were made by either defendant.
Hi, Rita. Welcome in.
Hi, Rita. Good to see you. So yeah, there's organizational issues there. In examining the complaint itself, the court notes that I gotta do the glasses real quick.
Oh, I'll clean here. I'll do it. I've got my cloth. I did see some nice. I starred something because I didn't want to interrupt you.
Okay.
What did I do with that?
There was one about a book that you guys should read called Autism Out Loud.
Oh, okay.
I wrote it down.
Girl Mom says, me and my husband were talking about the greatest lawyers of all time. Who do you all think the best lawyers of all time is?
Tom Cruise.
You can't handle the truth.
Right. That was
I
like
don't
one
know.
of my favorite ones. He wasn't a real lawyer.
Of course, you'd go straight to movies.
I just watched that recently, so.
No,
don't know.
that's a great movie. Greatest lawyers of all time. Matlock. No, just kidding.
People are saying OJ lawyer. Actually, they said a few.
Johnny Cochran.
There.
Yeah, Johnny Cochran was good. What was the lady lawyer I really liked in that case? Marsha Clark.
No,
She lost.
she was horrible.
I know, but I
You
like
just remembered her name. You remembered her name.
No,
she was horrible.
Greta Van Susteren was good too.
Am I wrong?
What?
Marsha Clark?
Marsha Clark was horrible.
Well,
No, I didn't think she was horrible at all.
Um.
But Johnny Cochran was the star there.
Well, Andrea Burkhart.
I guess you could say Aaron Brockovich.
Yeah, everybody. I mean, the OJ team is kind of like the most famous legal team probably ever, right? So
right.
That's, F. Lee Bailey. Someone says is absolutely the best. Okay, somebody's saying Alan Jackson, free Karen Reed. So Jackson, it's Jackson. I haven't been following that case. It's Jackson, Karen Reed's defense attorney. Is that who?
I
it is?
don't know. I have
Oh,
that's one case I've not really been that
Mystery,
enthralled with.
right.
yeah.
Yeah, I don't even know how to pronounce the prima facie or whatever it is.
Robert Kardashian.
Yes, one of the Kardashians.
Funny one.
I thought Marsha
Nancy
Clark did a
Grace,
great
yeah.
job with the prosecution
Oh.
on the OJ case.
That's a Nancy Grace. Right.
Yeah, I know you don't.
You forget about that.
You do kind of forget that.
Let's
I
see.
think I was here. Man, this is it. It looks like it's actually getting smaller.
I think it
The
is.
font. In examining the complaint itself, the court notes that as an initial matter, and as plaintiffs themselves state in various submissions to the court, the overwhelming alleged counts in the complaint purport to state claims for violation of state and federal criminal laws. As such, they are inappropriately pled in the civil action that on its face seeks injunctive and other equitable relief in the form of, in essence, silencing the defendants. Indeed, beyond plaintiff's description of the requested relief, evidence attached to defendant anti-slap motion reflects that the complaint was brought for the very purpose that Pennsylvania's anti-slap statute was designed to combat, to cause defendants to spend money defending against and if you don't mind to change it for me, would someone mind to change the page? Oh, there we go. Lawsuit regardless of merit. It's actually going to file a civil suit against you. And okay, so who said this?
There's got to be a way to make this bigger.
Someone said, I'm actually going to file a civil suit against you and make you pay to defend it. Don't even care if I win. Screw filing a cease and desist. Waste of time. Stand by. I was done with you, but oh well. We're not asking for money, etc. Okay, and then yeah, so we've heard this before actually. And the other thing, Nick the Hat posting on a live chat replay. We're not asking for money, etc. If they end the nonsense Monday, this could be settled Tuesday. The repeated references to criminal conduct, criminal liability, and the alleged involvement of the former Attorney General of the Commonwealth of Pennsylvania, as stated both in the caption of the complaint and in various averments in its body, suggest that if it was the intent of at least some of the scriveners to scare the defendants into believing that there could be or might be criminal charges filed against them. The exhibits appended to defendant submissions, the communications from plaintiffs Mathis and Nick the Hat, certainly support the conclusion that plaintiffs intended to scare defendants from continuing to broadcast podcasts or else be tied up in litigation solely for litigation's sake. Stripping away the invoked criminal counts, the purported violations of the civil statutes and torts attempted to be pled in the complaint appear to be the following. Civil conspiracy alleged by Bullhorn Betty, defamation alleged by Brittany J. I don't know who that one is. Tony Mathis, Chasing Crime, and Nick the Hat.
Oh, wait.
Oh, Bullhorn Betty. Intentional infliction. I just read
You're
it.
the worst.
I know. I don't know everybody's real names. Intentional infliction of emotional distress alleged by Bullhorn Betty, Brittany J., Seth Rogers, and Chasing Crime, I think. Interference with prospective business alleged by Bullhorn Betty, and invasion of privacy, public disclosure of privacy facts and false light alleged by plaintiff Chasing Crime. All other counts, claims, and allegations against the defendants reference purported violations of criminal statutes and laws which do not form a basis of civil action. Therefore, any count that purports to set forth violations of a criminal law cannot be a basis for recovery in the civil action and fails as a matter of law. As such, and put differently, defendants are entitled to judgment as a matter of law as to any purported violations of criminal law, and those purported counts must be dismissed. As to potential counts that appear to raise potential violations of civil statutes or torts, do you mind to change that for me? Plaintiff Bullhorn Betty alleges that both defendants conspired with third parties in order to defame her. The elements of the common law claim for civil conspiracy are a combination of two or more persons acting with a common purpose to do an unlawful act or to do a lawful act by unlawful means or for an unlawful purpose, an overt act done in pursuance of the common purpose, and actual legal damage. Okay, in count 3, Bullhorn Betty alleges that Granny's Watching has been targeting Bullhorn Betty since 2021, but the attacks intensified in 2024. Bullhorn Betty makes bold and bald allegations that defendants have acted in concert in a coordinated effort to attack Bullhorn Betty with no specificity as to the acts of either or both defendants. At best, Bullhorn Betty averts the court identifying various causes of action, including defamation, that defendant Granny's Watching called Bullhorn Betty a tragedy pimp and a grifter, with no reference to when these words were spoken. But calling Miss Griffin names does not create a civil conspiracy. Miss Griffin also alleges that unnamed persons influenced by Granny's Watching made false reports that led to Bullhorn Betty being falsely accused and arrested, again without specificity or any attached proof of who these persons are or how these purported persons are connected to either of the defendants, nor does the complaint identify the date of the purported arrest or the dismissal of any purported charges. Moreover, Bullhorn Betty fails to plead, let alone establish a prima facie claim for an actual damages, although Bullhorn Betty makes a vague and general allegation that the conduct of defendants damaged her reputation in her profession and her professional standing. She does not identify any facts pertaining to any persons or businesses which have purportedly canceled or decreased any business with her as a result of defendants' actions. Such specificity is required in the Commonwealth. Then cites a number of laws.
And I wanted to welcome Crafton by proxy.
Oh, hi, Crafton by proxy.
He says, wait, you mean there's more than 2 pages of this thing? Astonishing.
We are in the home stretch, though. I think we've got 7 pages to go. And yeah, I'm glad we didn't. I'm glad we didn't try to do a second live.
Yeah, I don't know what we were thinking. We were very ambitious. Very ambitious. Oh, happy Easter to you, Donna.
Thank you very much, Whispering Winds.
You know what? I didn't pay much attention to Marcia Clark. I'll just.
Oh, we're at 500.
Are we?
Yes.
You want to have a machete party?
You know what? Do the machete party. I need to grab a new water anyway.
Okay.
And I'll be back.
All right. Do you want to do the? I can do it. You're looking at chat.
Yeah, I'm keeping.
All right.
Let me have the current comment.
All right. It's time for a machete party. All right. I have to find it now. Okay.
She also said she was going to bring a machete.
Karate.
Machete.
Karate.
Machete.
Karate.
Machete.
Karate.
Okay, we do 3 times here.
She also said she was going to bring a machete.
Karate.
Machete.
Karate.
Machete.
Karate.
Machete.
Karate.
One more time.
She also said she was going to bring a machete.
Karate.
Machete.
Karate.
Machete.
Karate.
Machete.
Karate.
Good one.
Love it.
Best side look. Yes.
Yeah, I actually have that separated out just so we can have it. One more time. The best side I ever.
He does that so well. It seems to be everybody's favorite.
It is the best. And I think we had a new member somewhere. Maybe I'm crazy.
Rosebud had a good question. She said, do you think the defendants will be rewarding monies exceeding just legal fees and court costs? They did say that they could ask for certain fees, extra fees, but it was not real specific. So
no,
it was 3 things. It was court costs. Mr. E might remember what it was called.
He doesn't have his headphones on yet.
Okay.
I hope that was worth the wait. We love the machetes.
Rosebud had a question. I thought maybe you could answer that.
Question: do you think the defendants will be rewarding monies exceeding just legal fees and court costs?
There was one other thing it was covering besides those two. I don't remember the exact terminology.
It's something like
It wasn't
expenses,
damages, expenditures,
something like that. Which I'm guessing would be like
paper,
ink, stuff like that. Maybe
filing fees.
I think, yeah, but I think that's.
I think that's on the last page, though. We'll get to that.
But I don't think so.
I don't think it'll be a lot more than legal fees.
I did not see Conquer become a member. I'll tell you guys, I apologize if I've missed some of your comments. StreamYard is omitting things, and I don't know what's going on.
Yeah,
It's acting really weird. They're not all showing up, so I'm having to switch back and forth between that and the YouTube studio, and I apologize if I'm missing anything, but I believe they're saying that
Conquer said they joined on another live. On a previous live, but they are showing up as a member. They're green. So.
Oh, okay. Well, that makes sense. Okay.
Yes.
Well, thank you for becoming a member. Oh, you did it on replay. Well, thank you. And I will play you a Dog Pound song when he's done with this. I promise.
We're getting there.
And somebody else just added in here: plane tickets, gas, tolls like that get to court. Get to court. Okay, so travel.
Yeah, they can, but like if they have to have a hotel, anything like that, that's an expense for court.
I see.
Okay. Did I read this page?
I don't know.
No.
We should have had you reset while you took a break.
What page? Oh, we're on page 20, right? Yeah, no, I haven't read this one.
So, well, that I just put 19 up, and you said
this is
19 was on Bullhorn Betty. Plaintiff alleges that both defendants conspired.
Oh, you're right. Yeah, we can go to the next one. I read that.
That's what I thought.
Sorry.
Okay.
Barnes Foundation. In light of the foregoing, the court concludes that the complaint fails to establish a prima facie case of a legally sufficient claim raised by Bullhorn Betty against defendants of a civil conspiracy, and that claim must be dismissed. Defamation. Plaintiffs Bullhorn Betty, Brittany J., Tony Mathis, Jason Crime, and Nick the Hat allege various counts of defamation against defendants. And then it cites some laws based on complaints allegations. Each of these plaintiffs is either a public figure or a limited purpose public figure under Pennsylvania law. That is, as noted by the Pennsylvania Supreme Court. A limited purpose public figure is an individual who voluntarily injects himself or is drawn into a...
Is that easier?
Yeah, for sure. That's great. I can't see the chat, but that's okay.
That's okay. You weren't able to do anything with it anyway.
Yeah. So you'll just have to highlight stuff if you like.
Mm-hmm.
So anyway, I've never heard that phrase, but a limited purpose public figure is an individual who voluntarily injects himself or is drawn into a particular public controversy and thereby becomes a public figure for a limited range of issues. To determine such status, it is necessary to consider the nature and extent of an individual's participation in the particular controversy giving rise to the defamation.
Limited purpose public figure. Huh.
Yeah. We did kind of talk about this when sometime, I don't know if it was during this or not, but we've talked about this in the past where like defamation, the more high profile a person becomes, the harder it is to win a defamation suit against that person. Like the president, or whatever, is really hard because they are the most out there and can defend themselves and
I see. I see. Okay.
Where like Joe Schmo can't defend themselves or correct the record or whatever. And so they have this definition of a limited purpose public figure.
Gotcha.
Yeah, the idea is that like you almost can't defame a president in a way, or it's hard to, because they have the biggest platform on the planet. They can.
That's interesting.
Yeah. So there's a balance or whatever. A controversy may be created by the individual's own actions. It is clear, based upon a thorough reading of the complaint and the presentation of counsel at oral argument, that Bullhorn Betty, Brittany J., Tony Mathis, Jason Crime, and Nick the Hat are public figures or limited public figures, as they have injected themselves into the public eye to find the missing child from Tennessee. These plaintiffs have either held press conferences, appeared on the television news, or have engaged in social media discussions and/or created social media posts related to the missing child. As public figures or limited purpose public figures, these plaintiffs have a higher burden when raising allegations of defamation due to the inherent right and claims of free speech granted in the First Amendment. As public figures or limited purpose public figures, these plaintiffs bear the heightened burden of establishing that the statements made by defendants were false, but plaintiffs have failed to establish this in their complaint. First, this court reiterates that the complaint is devoid of the clarity required by the rules, and as a result, it is difficult to discern what, if any, statements at issue here can be attributed to either defendant. Even if the court were able to ascertain the allegedly violative statements of opinions that cannot be established as provably false, as protected by the First Amendment. Yeah, the provably false. So
But what if they accuse them of doing something that was breaking the law, and there is no legal record of them breaking the law? Isn't that defamation?
Yeah, right. Like the felon.
Yeah,
that's when people do all the time. They'll call someone a felon when they're not a felon.
yeah,
And if anybody ever chose to pursue it,
Mm-hmm.
yeah, because it's easily provable. It's not like you're a felon or you're not. So if you accuse someone of being that publicly, you kind of open yourself up to possible defamation suits. That's the example I always think of, because it's kind of like it's a night and day. I mean, it's obvious.
Some people just use
it's something
that.
you can find out.
Yeah, but some people use that word kind of as an adjective and not necessarily describe. They'll say, "Oh, he's hangs out with a bunch of felons."
I know, but they shouldn't.
That word is used a lot, loosely.
I know, but they shouldn't do it.
No, I wouldn't either. No.
It's a mistake, because it's not like calling somebody a crook. Like, you call somebody a crook almost, and like that there's some nuance to what that could mean.
Right.
A felon has a definition,
Right.
But anyway, that's the one and you hear it all the time. But do you mind to change the page for me?
I don't mind. I didn't know if you were gonna.
I think I finished it.
No, that giant law was underneath it. So.
Oh yeah, I'm not reading the giant laws.
Yeah.
Moreover, an expression of an opinion does not give rise to a claim of defamation. As to Bullhorn Betty and Brittany J. only, the complaint identifies purported directed quotations of the purported defamatory statements of only Granny's watching. Ms. Bullhorn Betty claims to have been defamed by Granny's watching by the statements tragedy, pimp, and grifter. Brittany J. claims to have been defamed by Granny's watching by statements that she has a lazy, wasteful piece of S, and that defendant Granny's watching stated, "You won't ever catch me driving with my children unbuckled and standing up." But there is no identification of any specific time when these statements were said, or any evidence other than the bald accusations not verified by plaintiffs Jackson or Griffin, corroborating the suggestion that these statements were made by defendant Granny's watching. There's also no reference to who heard these purported statements and how these statements were said, or that they caused actionable damage to either plaintiffs Brittany J. or Bullhorn Betty, while she makes a vague and general allegation that defendant Granny's watching and calling plaintiff Jackson a lazy, wasteful piece of S caused her humiliation, damaged her personal and professional reputation, and or affected her professional standing. The complaint does not otherwise describe Brittany J's purported professional reputation. Further, the complaint does not identify any person who heard the statement or describe how these purported statements have caused a loss of these plaintiffs' credibility. Again, such specificity is required in the Commonwealth under Rule. You had a thought?
Yeah, go on and read it. That's fine. I do have a thought, though.
Oh, go ahead.
I understand what the judge is saying, and it makes sense what she's saying in reference to the outside of YouTube world.
Yes.
But in the YouTube world, it's very different, and I don't believe the judge understands.
Sure.
Does that make sense? Does that make sense?
Yeah.
Because in the YouTube world, it can cause a loss of reputation.
Oh yeah.
To say things like that.
Oh sure.
So I don't know.
But yeah, and
do you know what I mean?
Yes. But I guess she needs it.
She needs it in a real world scenario.
Needed it detailed better for her.
I think they didn't have the time. They didn't have the video stamps, or there were things that were missing that if they had been there and she heard them, and that could have changed the opinion. But the way it's stated, there wasn't really the evidence specificity that was needed to clarify the allegations.
Yeah.
So she's essentially saying she needed it to be more specific.
Yeah, like she's
Yes.
asking for that. Sometimes there's not a specific date or a specific person that heard it, or what
Right.
She wanted more
Clarity.
cause effect, exactly
Mm-hmm.
how this happened, and this injunction request didn't have all those details at times, and
Yeah, it should have said on March 3rd, this person said these defaming remarks, and then they should have had the recording attached. And there should have been evidence when you purport
See, that's
these
the thing. I
things.
believe that's
That's
see,
what
I
I'm
don't know.
confused about.
I feel like that's not what I don't know. I need to I would need to know more about it before I could say anything, but I feel
Right,
like
right. But if you take the reading as what it says, they didn't have what they needed to make that judgment clearly.
yeah, I mean, this
but
And that's what the judge said.
that's what the judge is saying, but I don't know that I don't know.
that's
Well,
their
I mean,
opinion. I mean, that's their
the judge's opinion.
That's their judgment, and
Yes,
a different
and-
judge might read it differently.
Right.
Of course, they could. That's just how this that's just how this judge is interpreting it. But
Right. Rob's kind of saying what I'm saying. What I was saying is that,
right.
right. But see, the judge lives in a different world, and we talk about this all the time. Before we started a channel, we had no idea this world existed. We had no idea.
Mhm.
yeah, so what you'd have to show, like an example, like if someone's sending people over to harass you,
Disrupt your
maybe
chat?
actually show the comments, the chat, and that they were in the other person's chat an hour before, or what
Right.
like
I see what you're saying.
more of a like the evidence that occurred.
Right.
Right.
See what Just Iris said? Yes, the evidence needs to show patterns. Yeah.
And honestly,
And
June
that's
had-
what I was going to say, Kelsey. There is proof.
Yeah.
There are patterns of behavior. I agree.
Yeah.
and then also June said she thinks our laws are behind when it comes to the rapid growth of social media. I do think there's a whole different world in social media that new laws need to be created to control some of that. It's almost like swatting. Like
it is. You're right.
it's like swatting
Yeah.
on social media.
Yeah.
And that kind of stuff exists. It happens. We even
Sure.
hear creators say, okay, everybody go over to their chat and give them
Sure.
hell, things like that.
Right.
And so that, that's in a way kind of a tactic to dissuade people and keep them from saying things or to cause problems.
But try to, if somebody's not in YouTube world, try to explain that to them. You almost,
Right.
it's very difficult, because
We've
understand
tried.
I didn't understand it.
We've
till we did
tried, and it gets so complicated. It's not even worth trying to explain to someone who doesn't go on YouTube.
Right.
this. Crime Cafe asked, did the attorney not get the actual evidence of these things? I'm not sure what evidence they actually received. I mean, they did receive some evidence, it seems, just late.
And
But
it
I don't-
sounds
I don't
like
know
they
what-
didn't have enough.
Well, that's what. That's the thing, and we talked about this. How many pages is the Bible?
I don't know, but this was
million?
supposed to have been 200,000 pages. But that's what we're. This might have just been just almost spiraled out of control.
So
That it
daunting
was so huge
that she just
that-
said, "Nah."
that mistakes got made in the organization.
And it could be that it was too hard to sift through and it was actually there, but it was too difficult. And maybe because it was so big, it didn't go to the depth it needed to prove each of the counts.
Right. They maybe should have honed in more on the strongest items,
Mm-hmm.
Hi, Zoots. Welcome in.
Yeah, right. Zoots and Boots says, hey guys, each argument should have been presented like a YouTube short video. A digital world is waiting for real world laws to appear. Thank you, 3.
That's
Thank
so
you, Zoots and
true.
Boots. That's
Yes.
good. Yeah, and
Very
I
good point.
thought that was going to always be a difficulty for this. The challenge would be it's just so hard to explain this corner of the internet. Perfectly imperfect boy mom. Can they go back and resubmit with more specifics and evidence? I don't know. I don't think they can resubmit.
Because it's with prejudice, right?
Yeah. So I think they can, if I understand, I think they can appeal. What I don't know is, can they almost look at this judgment and go, well, here's some mistakes that, we can almost edit and make a better argument for the appeals court, or does it have to go with everything they just submitted as is? Can they, tighten it up? I don't know. Real Me Too. Hey, Mr. and Mrs. E.A.T. I didn't even know you were alive.
Mm-hmm.
I know, little surprise.
We did a
live.
little live ambush.
Yeah, we did.
Let's see. All right, you ready to get back to it?
Did I finish this page?
This is like our new game.
I know.
It's our new game. You were about 3/4 of the way through when I started kind of.
I think I was here.
Yeah.
I think I was at similarly as to plaintiff Bullhorn Betty. She also makes a vague and general allegation that defendant Granny's watching, calling her a tragedy pimp and grifter, and purports that this is evidence of defamation per se and caused damage in professional reputation. The complaint does not otherwise describe Bullhorn Betty's purported professional reputation. Further, the complaint does not identify any person who heard these statements or describe how these purported statements have caused a loss of these plaintiffs' professional credibility. Against such specificity is required in the Commonwealth under Rule 1019. Okay.
You ready?
Yeah. I'm just thinking what kind of evidence they could provide for those situations. Would you have to show like the number of watchers somebody had?
It seems like that would be really super complicated. What
views.
she's asking for specifically would be really complicated.
That would be really hard.
Mm-hmm. Mrs. Magoo, hi guys, how's your son doing? He's doing well. We have a big MRI coming up on April 22nd, so we are asking for prayers. We need clear results. He's in between treatments right now. We did have a little scare and had to go to the emergency room yesterday, which I'm exhausted from still. I did sleep last night, but I'm really tired still. I don't know why.
But he's doing great right now.
He's doing great right now.
Yeah. So
thank you for asking.
Thank you. We just
we just need prayers. But thank you for asking. That was very sweet.
He does better than mom and dad.
For sure.
Yeah. Kids, they're, resilient.
Real Me Too says, I believe they're going to refile. Like start from scratch.
Oh.
Take a different approach.
When we get to the end of this, it sounds like they can't, but there's so many different legal maneuvers people can do. You just,
I agree with Rob. The courts are going to end up being forced to do something because of the amount of cases being filed. I mean, if you think about just around the Sebastian case, there's like lawsuits here, lawsuits there. I mean, there's back and forth lawsuits, people suing each other. I don't, it's crazy.
Yeah. And if you are, I know there's some of y'all watching that are not regulars with our channel. The reason we covered Bullhorn Betty and this case specifically is because these involved all three parents, in both situations. Whereas when other lawsuits happen with YouTubers, we wouldn't talk about it at all, but it's all three parents were involved in this and in the Bullhorn Betty. And so you had potential for, like we had in Bullhorn Betty, we had both parents, the stepdad and the mom take the stand, give testimony, sworn testimony. That's all interesting when you're covering this case. And with Seth as a plaintiff, and then it looked like in that original filing that Chris and Katie might have been one of the 50 does, and if depending on how this all played out, they could have been involved. So, I mean, at this point, that's all kind of halted. But that's why we were covering these cases, is because really the parents being involved. If this were just all between YouTubers, we wouldn't have talked about it.
Ginger, the MRI is early in the morning that day. I'm not sure. I can't remember exactly what time, but it's early in the morning.
Yeah, I think it's like 6 a.m. or something like that.
Yeah,
right?
something like that.
Like really
wow,
early.
That's crazy.
Yeah. Like, I don't know how we're gonna do it.
Oh, it'll be fine.
Sleep in the parking lot.
No, that silly goose. No.
Anyway, so we're close here. We're on page 22 of 26. Moreover, there is no allegation that would establish that any of these statements were false, and to the extent they were defendant Granny's subjective opinions, they are not actionable. As to the claims for defamation purportedly asserted to plaintiffs Mathis, Chasing Crime, and Nick the Hat, these plaintiffs too are public figures or limited purpose public figures. A review of the counts of the complaint filed by these plaintiffs reveals not one single quotation attributed to either Granny's Watching or Barbecue Lady. Plaintiffs Mathis and Chasing Crime merely allege that defendant Barbecue Lady made statements that they say are more than mere insults and damage their reputations. Plaintiffs failed to plead with specificity any of those statements. Additionally, Nick the Hat identifies neither a particular defendant nor a particular statement, merely stating that defendants made several false statements. Altogether, Bullhorn Betty, Brittany J., Tony Mathis, Chasing Crime, and Nick the Hat have failed to establish a prima facie case of a legally sufficient claim for defamation against defendants. As such, defendants are immune from suit, and these claims must be dismissed. Okay, so there you have that. So that's dismissed there. Intentional infliction of emotional distress. Plaintiffs Bullhorn Betty, Brittany J., Seth Rogers, and Chasing Crimes purport to state claims of intentional infliction of emotional distress. And to prevail in a cause of action, a plaintiff must establish the following. The conduct must be extreme and outrageous. The conduct must be intentional or reckless. It must cause emotional distress, and the distress must be severe. Okay. Moreover, plaintiff's complaint must demonstrate to the court that the conduct of defendants was so outside the bounds of decency that the conduct was atrocious and not tolerated by civilized persons. A thorough reading of the complaint leads the court to conclude again that plaintiffs have failed to plead that with clarity and or specificity and cannot demonstrate that the defendant's conduct was outrageous or extreme. Once again, this court notes that the alleged YouTube podcasts have not been quoted or specifically. Do you mind?
You should be able to do it now.
Oh, I can? Why? What happened?
I fixed it.
Oh, okay. Well, look at you.
And I wanted to tell Ginger for op real quick. It's supposed to start at 7 a.m. on that day. So she was saying that they wanted to do a prayer at that time, a group prayer.
Thank you very much.
That's Central Time. Thank you so much.
Without the specific statements of defendants vis-a-vis the plaintiffs asserting an IIED claim, this court cannot determine that any statement was so atrocious or outside the bounds of civilized society to have caused a harm to plaintiffs. The few quotations and purported statements of defendant Granny that are contained in the complaint that Barbecue Lady is a tragedy, pimp, or a grifter, and or Brittany J. was worthless and lazy do not allow the court to conclude that there is a cognizable IEED claim. Further, none of the plaintiffs has pled that actions or statements or defendants have caused them to seek a medical diagnosis or treatment. There are only the threadbare allegations that these plaintiffs suffered emotional pain and mental anguish. As such, plaintiffs have failed to establish a prima facie case to recover for IEED counts, and these claims must be dismissed. Interference with prospective business. Plaintiffs Bullhorn Betty, something that you remember when Lesniak was on, and he was talking about a right to reputation. Pennsylvania has a right to reputation. Mm-hmm. So that appeared that, the kind of defamatory type of statements have more teeth or something in Pennsylvania, but she doesn't ever reference that. So I wonder if that's.
Well, again, I kind of go back to, I feel like maybe the laws are behind the times a little bit on some things. Sure. I'm not saying, I just think that what Rob is saying is correct, is that, the technology has surpassed the laws in a weird way.
Oh, yeah. Yeah, without a doubt.
And
they
everybody
specialized.
Right. Like there needs to be a whole section of laws for this, is what it seems like to me.
And some of this goes into I would think some of the cyberbullying type of laws that are in other states. It kind of needs to be encompassed in that.
Elisa P. Thank you so much. We appreciate that. And Zoots, he's had how many MRIs so far? He's had one before surgery, one after surgery.
2.
He does great with the MRI. He's
Yeah.
really good with it. They don't, he's good with it.
But yeah, he does a really good job with it. But
Yeah,
thank you for your concern.
but
I
thank you.
appreciate it. And Ginger says, "Were there 2 or more gathered in his name?"
Thank you, Ginger.
Thank you. Let's see.
So I'm gonna go on with interference with prospective business. So Bullhorn Betty purported claim of interference with prospective business also fails for lack of any specific facts to establish this claim. To prevail on a claim of tortious interference with prospective business, Bullhorn Betty must establish that she had prospective contractual relations. The defendants acted with purpose or intent to harm Bullhorn Betty to prevent those relationships from occurring, that the defendant had no jurisdiction to act in the manner they did, and that Bullhorn Betty suffered actual damages. In Pennsylvania, complaints must be pled with specificity and not simply provide a cursory ground for the tort that defendant is alleged to have violated. The complaint must provide the facts that are essential to the claims raised. Bullhorn Betty's allegation pertaining to the purported claim of tortious interference with prospective business is as follows. Defendant's repeated defamatory remarks and encouragement of harassment against Ms. Bullhorn Betty constitute such improper conduct, preventing her from securing work and maintaining professional relationships. This complaint, like in one of the Foster case, fails to distinguish between the prospective or existing contractual relationships and fails to set forth any facts that would establish that Bullhorn Betty was entering into any contracts with any business, let alone an interference with such contracts.
See, and that part just really is silly because her business is with YouTube, and so it does impact that.
That's what I'm saying.
And it can't impact it negatively. It has nothing to do with doing business with other people. I think that is outdated terminology or explanation.
Yeah, I
mean, she only has the laws to work with. You know
right,
what I mean?
Right.
She only has the laws that that the state has to work with to, provide a ruling too.
Right.
Justice Jane, that's a good point. And hi, welcome in. It's so good to see you.
None of them have lost money. If anything, they have gained from their subscribers that don't know any better, contributing to this mess. All of it can be ignored, but they don't, in my opinion.
Yeah.
Yeah, I mean, it's a fair opinion. This interference with such contract, that's very specific.
Mm-hmm.
Mm-hmm.
I wonder if that law is that narrow or if that's just her interpretation, because her business is not getting contracts.
Right, that's what I'm saying. This is
outdated.
Her business is a performance business.
It's almost
really.
like they need online laws.
Although I suppose somebody trying to get you deplatformed would be trying to break your
that's a good point.
You have with YouTube. Like if you could show that, like if somebody were trying to deplatform you,
like reporting you, falsely reporting, things like that, trying to get you deplatformed.
Yeah, if they could show evidence of something like that, that might.
But you'd have to show specifics. Yes.
Yeah, like you'd have to show the report or the attempt or whatever was made to get
Would that mean like with strikes and stuff
maybe?
Too? I don't know.
I'm just trying to think of like her interpretation of that. What would fit? Something like that might.
And like Kelsey said, even if it's outdated, you have to follow the law that we have right now. And the judge is basically telling you what to do. They're saying this is what you should have had in order for this to be approved. And you failed to have those things.
Yeah. So if they are able to refile, I mean, this will be helpful to them to clean up the stuff that at least,
But that's the thing about judges too, is a different judge could have received the same thing and ruled completely differently.
Sure.
Of course. Yeah. I mean, yeah, definitely. So Zoots and Boots says courts in time find ways to create effective streamlined systems like family courts, RRD rung courts, courts of arbitration, corporate laws, etc. In time, cyber courts will exist.
Yeah.
Yeah.
You're
I
right.
think you're right. You're absolutely right.
I think that's true.
Needs to be pushed to the forefront as far as cyber courts.
With people that understand it,
Mm-hmm.
doing it. Moreover, this section of the complaint does not identify which of the defendants made statements that interfered with Bullhorn Betty's perspective or current business relationships, nor does this section set forth which statements were made vis-a-vis Bullhorn Betty or when. All right. These alleged statements were made. As such, the purported claim of interference with a prospective business relationship is not supported by evidence and is therefore wholly deficient, as plaintiff Bullhorn Betty has failed to establish any facts in the complaint as to one or more essential elements of this claim. The defendants are immune from liability under Pennsylvania's anti-Slapp statute, and this claim must be dismissed. Invasion of privacy, public disclosure of private facts and false light. Plaintiff Chasing Crime is the only plaintiff who purports to state a claim for invasion of privacy, public disclosure of private facts and false light. Is a public figure who inserted herself into this public controversy of the missing child from Tennessee. She herself is a podcaster who goes by the handle Chasing Crime. Invasion of privacy is a complex tort that has 4 distinct causes: intrusion upon seclusion, appropriation of name or likeness, publicity given to private life, and publicity placing a person in false light. Plaintiff Chasing Crime alleges specifically that certain actions violated of sections B through D of the restatement, intrusion upon seclusion, appropriation of name or likeness, and publicity given to private life. The paragraphs relating to this count state the defendant, Barbecue Lady, invaded Chasing Crime's privacy by disclosing private facts, and that by disclosing those facts, they placed Chasing Crime in a false light. No paragraphs in the complaint prior to those set forth in Section 10 with respect to the civil claims for invasion of privacy, public disclosure of private facts and false light, contain any facts that specifically support these claims. And the only quotes contained in this portion of the complaint allege that defendant Barbecue Lady called Miss Chasing Crime a couch potato or drug addict. The paragraphs in this section of the complaint allege the defendant Barbecue Lady generally invaded Chasing Crime's privacy by disseminating information regarding her sobriety, her history as a human trafficking survivor, and that she had lost a child. There are no specific facts contained in this count or elsewhere in the complaint which demonstrates to the court that defendant Barbecue Lady disclosed any specific information about Chasing Crime. There was no allegation of the dissemination of any medical records, drug treatment records, or any other private records. As with all the prior sections of the complaint, plaintiff fails to identify with any specificity a YouTube podcast in which these purported statements were made or what the actual statements were. In sum, the plaintiff Chasing Crime has failed to establish the essential elements of a claim of invasion of privacy and or a cause of action for this count upon which relief can be granted. As such, defendants are immune from civil liability for this claim under the Pennsylvania Anti-Slapp statute, and the claim must be dismissed. All right. We're almost done, aren't we?
Mm-hmm.
I just want to see what. Okay, yeah. Last, the court addresses the fact, as noted here and above, that the complaint identifies Atnight Media in the caption and in the identification of the parties, but makes not one factual allegation by or on behalf of Atnight, nor does it assert any count or claims against any defendants on this plaintiff's behalf. Therefore, there is no claim by plaintiff Atnight Media as a matter of law. Similarly, as and also noted previously, the complaint identifies Dwayne Dog Chapman in the caption and the identification of the parties, but makes not one factual allegation or claims against any defendant on this plaintiff's behalf. Therefore, there can be no claim made by plaintiff Dog the Bounty Hunter as a matter of law. With respect to plaintiff Hong Ji, all purported counts against the defendants in the complaint are criminal in nature. Further, the purported count under the criminal statute concerning endangering the welfare of a child relates to the missing Tennessee boy, not plaintiff Ji's child. Therefore, this purported cause of action fails as a matter of law. Similarly, the complaint alleges counts on behalf of plaintiff G, Brittany J, Bullhorn Betty, and Chasing Crime for violation of the statute, the criminal section of the statute prohibiting cyberstalking a child. Once again, the allegations in the complaint regarding purported cyberstalking pertain to the missing Tennessee child, not any of these specific plaintiff's children. Therefore, these claims fail as a matter of law for this reason as well. It was Seth's child, though.
Yeah, they didn't mention Seth's name though.
Yeah.
Hmm.
I don't know. So I mean, Seth, maybe she doesn't realize.
I don't know. They don't mention him at all.
In sum, the court is constrained to agree with the defendant's summary. Although the text from Plaintiff Mathis is clarifying in its brutal honesty, we don't need it to prove that this lawsuit is precisely the kind that this legislature sought to curb. So that text ended up being, I think, persuasive for her, it seems. The complaint in itself has all the hallmarks of a slap. It's 83 pages, 350 paragraphs, and 300 pages of unattached exhibits. The complaint utterly fails to adhere to the most basic rules. Oh, I thought this was still her. Oh, well, she does say she agrees with the defendant's summary. So this, it's not her words, but it's her. She shares the opinion. The complaint utterly fails to adhere to the most basic rules of pleading in the state, forcing the defendants in this court to wade through its nonsensical claims to decipher the nature of the allegations against the plaintiff's claims aimed at defendants' right to free speech to allege. Failed to allege of any kind of requisite, particularly the content of the actual statements made, despite the fact that many, if not most, of defendant's statements and plaintiff's counsel admitted to during oral argument are recorded. Pennsylvania's anti-Slapp statute provides that a party may move to recover attorney fees, court costs, and expenses of litigation under Section 8340. Defendants Barbecue Lady and Granny's Watching requested such an award in their anti-Slapp motions. Pennsylvania's anti-Slapp statute is clear that if, as here, a court finds that a party is immune under this section, then the court shall award the immune party attorney fees, court costs, and expenses of litigation jointly and severally against each adverse party that asserted the cause of action. Then it says emphasis added. In light of the court's findings herein, including but not limited to that the defendants are immune from civil liability for the claims attempted to be pled in the complaint, the court must grant the defendant's request for such an award. While Pennsylvania's anti-Slapp statute does not preclude punitive damages, this court declines to award such damages at this time.
So it's only expenses and lawyers' fees and expenses to be at the litigation, basically.
Yes. So that was a question somebody had earlier. Are they going to be
Yes.
awarded damages? And looking at that, it will no. In light of the foregoing findings and analysis, it is hereby ordered and decreed as follows.
Sorry.
That's okay. Defendants' motions to dismiss the cause of action asserted against them based on the defendant's protected public expression immunity are granted. The complaint is dismissed in its entirety with prejudice. Plaintiffs are responsible jointly and severally for and shall pay defendants' attorneys' fees, court costs, and expenses of litigation and costs as required by law and an aside by the judge. So we made it to the end of that, but in a way that the last page, maybe the most important for all the parties, and a lot of this I don't really guess I'll know or understand exactly how what this means, but my understanding at this point is that by them saying the complaint is dismissed in its entirety.
Mistakes. Sorry.
That's okay. We're rusty. We were away from it. The complaint is dismissed in its entirety with prejudice. My understanding has been that meant they couldn't refile this exact same suit,
Right.
Or the same injunction.
It means it's a final decision. The plaintiff is barred from filing another lawsuit based on the same claim or cause of action.
Right.
That's the
What about
definition.
the defendant?
And then the defendants, I think, are not able to countersue. I think is that also part of that? Because I don't think they can.
It doesn't
I
say
don't know.
anything about the defendant. That's just the definition, what it legally means with prejudice.
Okay.
Oh,
No.
it protects the defendant from having to defend again against the same claim repeatedly. So it does, but it
Right.
doesn't mention the plaintiff.
Okay. So does this say? Well, does it indicate in here anywhere where it says whether or not they can do the countersuit, or does it just says that they can't? It just says statute does not preclude. this court declines to award such damages at this time. Does that stop a countersuit? That
I
statement?
guess it would because they have to. The judge has to rule on the countersuit, and so she's basically saying you can't receive damages.
Right.
I don't know about the countersuit though. I would not want to.
Yeah,
guess
I'm not
that.
sure. Yeah, I mean, there's at least at this time there's declines to award such damage. I just
Britt T said they absolutely cannot file again. The defendants can go forward at a later date. I don't know, if that's correct or not, but that's what she
I
said.
don't know. Yeah, so that's where that stands. So, yeah. So I mean, basically, things kind of go back in a way to the way they were prior. Of course, these folks are going to be, they'll have to pay their court costs and however that plays out.
What does jointly and separately mean?
I don't know. Let me see. Where was that phrase? I remember reading that. Oh yeah, back here it says court costs, expenses of litigation jointly and severally against each adverse party that asserted the cause of action. Court finds that a party is immune under Section 8340. Then the court shall award immune party attorney fees, court costs, and expenses of litigation jointly and severally against each adverse party. I don't know. Severally. Split, would that mean that the cost is split between all of them? Is that what that would mean? I don't know.
I'm looking it up. In legal language, severally means individually or separately, as opposed to jointly.
Yeah, so
If two people are jointly and severally liable for a debt, it means they both are responsible together for the full amount, and each one is individually responsible for the full amount severally too. So a creditor can go after either person for the full debt, not just half.
Gotcha.
So severally equals separately, jointly equals together, jointly and severally both together and each on their own. So that's what it means, both together and each on their own.
Yeah. So they can, if they think they want to go after one person for whatever it ends up being, $40,000 or whatever, they could.
They can go after one individual, or they can go after each person.
Right, but not but in total for 40.
Right,
whatever
they can't
the total,
go. Yes,
So
they can't sue each person for $40,000.
Yeah, and we're guessing it might be in that range, somewhere around 40,000, 50,000 ballpark, just kind of guessing. So that's where that stands. If they appeal or refile, like I said, I don't know what the mechanisms are for them here, what they can and can't to do. But the big winners, as always, are the lawyers. Because
They're the ones that,
they always come out ahead.
But I could tell that the judge was annoyed. They seemed very annoyed. You could hear the voice come out in the ruling. So I thought that was interesting. And Britt had a comment that I'm sure we all can relate to. She said, "I hope this can be about Sebastian only again. This was a frivolous lawsuit and was ruled as such." The lawsuits do mar down the process of looking for him and making the focus be about him. So I get your frustration there.
Yeah, I think a lot of people feel that way. That there's been a lot of attention on this. And maybe that's there are some silver linings to all of it. If it's, obviously it goes to appeal, that's a very long process. There's only so much attention any, YouTubers and the media are going to give an appeal, because it's just a long process. But
Rob C said, I think I read they get double the pay.
I don't,
I don't know anything about that.
I think that has to be in the ruling, though, right?
Yeah, I mean, I think she could have here. Apparently, she could have awarded. There is something that says that it says the court declines to award such damages at this time, and just that wording makes me think. Okay, at this time, is there an opportunity for her to award damages in the future? That's to me, that language sounds open ended, but I don't know.
It looks like Atnight has just put out a press release.
Okay.
Let me see if I can pull it up.
Is it on X?
No, it's on their website.
Okay.
Let's see. Hold on. Let me see if I can figure out how to do this. It's been so long. Okay. Sorry, it'll take me just a second.
When I'm not sure how to share this. Oh, well, you're trying to share something right now, aren't you?
Yeah.
Yeah, it looks like they just put this up 5 minutes ago.
Revised reward disclaimer with clarification issued for the disappearance of Sebastian Wayne Rogers. Contact 911 or authorities first. Philadelphia, Pennsylvania. Atnight Private Intelligence Agency affiliated with One World Society has formally released a revised and legally binding reward disclaimer effective April 18, 2025, pertaining to the reward initiative associated with the ongoing disappearance of Sebastian Wayne Rogers, age 15, now 16. This revision supersedes all prior language issued in 2024 or early 2025 and aims to clarify Atnight's role, reward eligibility, and the mandatory law enforcement reporting requirements governing this process. However, it permits individuals who provided information prior to the revision to qualify, provided they promptly notified law enforcement. Atnight's reward program has been operational since September 2024 and operates independently of law enforcement. It consistently encourages and prioritizes compliance with local, state, and federal regulations. Although the original disclaimer was technically correct in structure, it lacked plain language clarity that could mislead the public into believing that tips could be submitted to Atnight before contacting law enforcement. This has never been our policy. However, it is our duty to make this unequivocally clear now. Although the previous version alluded to legal alignment with federal investigative frameworks, it omitted the explicit requirement for law enforcement submission as a prerequisite. Okay, so this oversight resulted in misunderstandings among certain members of the public and media, despite Atnight's consistent emphasis across its materials and digital assets that 911, FBI, and local authorities must be contacted first in all non-theoretical, real-world tip situations. Atnight and One World assume full responsibility for this confusion and are committed to providing clearer legal and ethical guidance in the future. What has changed in the revised disclaimer? Enhanced security measures and compliance. Prioritizing law enforcement collaboration. All tips must be reported to law enforcement authorities prior to Atnight. Submissions made to Atnight without proof of police or FB contact will be automatically disqualified. Clarifying independence and accountability. Atnight operates solely on behalf of the family of Sebastian Rogers, particularly his father, Seth Rogers. There is no coordination with law enforcement, federal or otherwise, beyond escalation of ignored or mishandled tips. Expanded claimant verification. Atnight now includes mandatory biometrics, international database screening, and third-party digital forensics audits. Claimants must demonstrate that they have no familial or legal ties to suspects within a 5-degree familial relationship. Strict disqualifier. Submissions previously shared with media, monetized online, or altered in any manner are void. Well, yeah, sure. Intentional intelligence laundering, defamation, staged evidence, or public harassment of the victims or their families will result in public permanent disqualification. Updated legal structure and payment terms. Atnight operates under Pennsylvania registration and is in the process of legal incorporation in Delaware. Reward disbursements are deferred for 60 months following sentencing. Unless the board grants an extraordinary circumstances waiver, payments will be managed via third-party escrow, subject to independent audit. Global compliance and international vetting. Non-U.S. claimants are now subject to the General Data Protection Regulation, the Office of Foreign Assets Control, and the Personal Information Protection and Electronic Documents Act, as well as other cross-border validation measures. Why this matters. The revised disclaimer safeguards public safety, ensures legal defensibility, and upholds investigatory integrity, while simultaneously incentivizing the return of recovery of Sebastian Rogers or the lawful prosecution of any individual implicated in his disappearance. We kindly request that the public comprehend that any claim will not be considered valid unless submitted in accordance with the updated terms outlined in the new disclaimer. Yeah, well, that's good. I think that's good.
Mm-hmm.
That has been one of the criticisms of the reward, is people worrying that any pertinent information would not be forwarded to FBI or whoever. Right. So, in case people called it in only to the Atnight folks and not also to the feds or Sumner County or whoever. Right.
So the full disclaimer, this is the official rewards terms and conditions. Master reward scale and history.
Oh, yeah. Okay. So these are the dates that they increased that reward.
Mm-hmm.
This is they have a hard cap of 550.
No, it's 500.
Or I'm sorry, 500.
Yeah.
Yeah, because we're at 447 with that now. Well, that's good. I mean, we they had said they were sharing everything with authorities anyway, but doing it this way,
right,
by making it a firm rule that's clearer for the public, might ease some of those concerns and the criticisms that they'd had about the reward, because it's been a hotly debated topic.
Is this what you just read?
No, it's a little different, but it says for the non-factual corrections, it just said the original disclaimer stated the reward was fully aligned with law enforcement operations, and this has been corrected to clarify that Atnight operates independently with no direct coordination or alignment with law enforcement, acting solely on behalf of Seth Rogers. That was one of the non-factual corrections.
Oh, okay.
And it said the original disclaimer implied potential collaboration with law enforcement, and this has been revised to state that it wasn't.
I can make it bigger, but I think you should read it.
You think I should? Okay. I just from top to bottom?
Because it talks about the total maximum disbursement as well, right below that.
Okay. Retroactive coverage, all qualifying information submitted on or after September 4th, 2024. This legally binding reward declaration is issued as of April 18th at Atnight Media, hereinafter Atnight, a limited liability corporation organized under the laws of Commonwealth of Pennsylvania with pending legal registration for corporate restructuring in the state of Delaware. Atnight operates as an autonomous field operating division of Atnight Media LLC, a wholly owned and controlled subsidiary of One World Society, a joint cooperative entity finalizing merger and global integration with Original Media Group Corporation, a Pennsylvania-based nonprofit cooperative registered under applicable federal and state statutes. This disclaimer supersedes any and all prior statements, declarations, or representations issued by Atnight Media LLC, One World Society, or any affiliated subsidiary entity. It is binding and enforceable across all 50 states and applicable international jurisdictions, subject to compliance with local laws. Purpose and scope. This reward pertains to the confirmed and verified disappearance of Sebastian Wayne Drake Rogers, a minor male individual, and Summer Moon Utah Wells, a minor female individual.
So it's for both now?
I don't know.
Go on, read on down. I was reading on down. We hadn't got to that part yet.
Atnight offers this reward independently and acting solely on behalf of Seth Rogers. the father of Sebastian Wayne Drake Rogers, and not in coordination or partnership with any law enforcement agency, including but not limited to the Federal Bureau of Investigation, Tennessee Bureau of Investigation, DEA, U.S. Marshals Service, or any local or state law enforcement agencies. Atnight strongly emphasizes that all tips and information must first be reported to official law enforcement agencies before submission to Atnight, ensuring compliance with legal protocols and prioritizing public safety. Non-factual corrections. The original disclaimer stated the reward was fully aligned with law enforcement operations. This has been corrected to clarify that Atnight operates independently with no direct coordination or alignment with law enforcement, acting solely on behalf of Seth Rogers. The original disclaimer implied potential collaboration with law enforcement. Yeah, so that they're just clarifying because you could read that in such a way and think that it's an official government reward or something, and they're just separating this. The original disclaimer implied potential collaboration with law enforcement. This has been revised to explicitly state that Atnight is a private entity working independently with law enforcement as the mandatory first point of contact for tips. The reward amounts and conditions remain factual, as they are within Atnight's stated commitments, but enhanced safeguards have been added to protect Atnight from fraudulent claims and legal risks. Reward structure and threshold conditions. The total maximum dispersible amount under this reward protocol is $500,000, with a standing committed pool of $447,000 allocated as follows: $400,000 for qualified information leading to the live recovery of Sebastian Wayne Drake Rogers, or the full lawful arrest, prosecution, conviction, and final sentencing, with all post-conviction remedies exhausted, of any person legally responsible for his disappearance, harm, concealment, or abduction. If Sebastian is located deceased, the reward is reduced $60,000%.
60%.
60%.
What did I say?
You're getting sleepy.
I am.
That's a lot of reduction.
I'm shutting down. The computer's shutting down here.
60%.
Did I say
USD.
6,000%?
You said
Is that what-
60,000%.
60,000%. That is a massive reduction.
You get 20 cents.
Yeah, you're right. I'm sorry.
USD 240. This is the part that's crazy.
$47,000 for information resulting in the confirmed live recovery of
Of
Summer
Summer?
Moon Utah wells.
Wow.
That's interesting.
That's awesome.
Yeah, that's great. There is a reward for Summer, but it's not like that. It's not that big somewhere. I've seen them posting on X a little bit about Summer.
Yeah.
So
Sorry, I'm
I
all
wanna-
excited wanting to jump ahead.
okay.
Yeah, and I think
Yeah,
the
that's
rest of
great.
it was similar to what we read earlier about the you have to have proof of submission. You can't have put it on social media or disclosed it to other media.
Right. Is this worth reading the rest of this, you think? This is
I
just
think
all
that's the same thing
clauses.
you just read.
Yeah.
Payment structure, it tells how that will be issued in a single lump sum via certified financial instrument.
Cashier's check, wire transfer.
I think, I mean,
Yeah.
I don't know Summer's case anything like we do Sebastian's, of course, but there are one thing I think is similar with Summer, just the bit I've listened to other folks cover that case, is probably several people that do know what happened to her. And so maybe the money could get them talking.
Wow, this is very transparent.
A lot of the theories are, imply or would involve multiple people, which I think is probably the same case as Sebastian.
So are these posters? What are the?
Look at this.
Where was this? This was on X.
This is on their
No,
website.
it's on their
Oh, on
website.
their website.
I got an alert.
Missing in America, children's lives matter, don't they?
So
America
this
First,
is a new
Nationwide.
billboard or new what?
Well, we skipped ahead, so I don't know.
Go back a little and see what it says. Does it say?
It's a beautiful billboard if it's a
I
billboard.
know.
I know a lot of our audience followed Summer Wells back when that was
I'm not even
happening.
following.
Oh, it
that
does.
right
It
now.
does say under the Sebastian poster, it says, "Please note that an additional unofficial poster will be created for Summer Wells, instructing individuals to contact the lead agency and provide their tip there if they choose to. They may also contact Atnight. We've received tips about Summer since the beginning of the Sebastian case and have acted on each one, relaying them to the appropriate authorities when necessary. Summer Moon Wells, a 5-year-old girl with blue eyes, short blonde hair, and last seen wearing a pink shirt and gray shorts, possibly barefoot, vanished from her home on Ben Hill Road in Rogersville, Tennessee on June 15th, 2021. Despite years of investigation by TBI and local authorities, Summer remains missing. In response to mounting public concern and intelligence analysis, One World and Dog the Bounty Hunter have independently allocated $47,000 toward the credible information that leads to her recovery or the arrest and conviction of anyone responsible. It is important to note that does not represent any individual or family in connection with Summer Wells' case. This effort is independent and unaffiliated with her family or legal guardians.
Wow.
And then keep going down. There's more. It just says graphic. And then it says on April 18th, Atnight debuted the Sebastian Wayne Drake Rogers and Summer Wells dual billboard in Nashville.
Wow.
Oh, they're going to do a dual billboard in it. Yeah, I don't think I mentioned this, but
that would have been what's today? Today's the
18th.
8th.
That's today.
They did one today.
Oh,
I saw it Sunday.
wow.
I've seen
You saw
one.
the Sebastian one.
I saw Sebastian. Yeah, not this one. I don't. It was so far away I couldn't make out the words, but I saw it on
Wow.
in Davis County.
You
That's
saw his face
interesting.
and caught your attention.
I saw his face, but I couldn't. It's the same. But I couldn't
You were
tell.
driving, so you couldn't really.
Yeah, I was pretty far away, but I could. I saw it once at least.
That's amazing.
But
yeah, that's
hopefully
great.
that will
I mean,
lead
that's-
to some new leads for her.
That's amazing.
With her case, I always think of Chris McDonough. He said when he's talked about it, he says this is a solvable case. If you have the right people working it, and just the bit I've seen of it, it seems like it could be. Theirs is a different situation, I think, but
I can't get over how beautiful this is.
that's
That's
great
incredible.
layout. That's a powerful layout.
Mm-hmm. I like the dark light contrast, and their faces are so prominent. I like that. I like the slogan hashtag America First. We vanished twice. Let's start with hashtag Children First.
Yeah,
I like that.
This has actually become my favorite picture for Sebastian.
Oh, yes, I agree 100%. Those dimples just get me.
Yeah, that's my favorite one.
I like the children's lives matter.
Yeah, whoever did that layout did great.
Well, how about that? We broke something.
Wow.
There might have been other visitors to the website.
Oh,
possibly.
that's true.
Maybe. I don't know.
We broke something.
Look at us.
Oh, Seth.
Oh, is that the very last? Oh, wow.
It's a great picture. They're both good pictures. Yes, somebody else said both of them are such good pictures. That her eyes are just absolutely riveting.
Yeah, that's just it. It's just one of those things. When you see it, it'll get attention. That
I can see Seth in his face there too.
Yeah,
mm-hmm. You really can in the eyes, especially.
I don't think I've seen Seth without facial hair other than a picture, but I'm guessing he's got dimples like that too.
Oh yeah.
That's my guess. Seth.
That's a great picture.
And thanks for coming by, Seth. Yeah, and like we were saying on silver linings of all this kind of stuff, and hopefully everybody's attention will kind of get refocused back on case discussion, on Sebastian and others.
There's been some good work that we need to talk about.
Man, we've got a lot to go through because we haven't really talked about Sebastian's case in a month, basically.
Sad.
And so, but we want to kind of give our 2 cents on all of it.
Yeah, we've got a lot of stuff that we've been so busy we've missed out on being able to discuss.
Yeah.
And it's probably old news to some of our followers, but we haven't talked about it. So
No, but we will. So I mean, in a way, I mean, we'll give updates if anything happens with the appeal and that kind of thing. But there won't be any reason to go to the deep dives from here on this. Dimples are important. Chick magnets.
It's such a lovely picture.
And I mean, if and these two kids, so many people know their stories, and to have them together, and it's good. It's good.
He is so handsome.
Yeah,
so handsome. I'm partial to blondes too, so can't help it. It's just my nature.
Her eyes, though, they're just so deep.
I
mean, you can see all the way to her soul. It's just, they're just amazing eyes.
Yeah. You still haven't watched the Chris McDonough?
I haven't. You have been saying for a long time you want to do it where I'm seeing what's happening in real time.
Yeah.
So, but I don't know if we want my reactions in real time to that.
You kind of know what's coming anyway.
I have a feeling that it was not a good situation.
Well, I mean, if they're going to try to, so there's some reason they're. I mean, why now with Summer, right? I mean, it really, in a lot of ways, the Summer case is pretty cold. I don't think Sebastian's case is cold, but hers is. I don't know if anybody's really actively working on that anymore.
Don B.
Well, Don B. Yeah, no,
Don B.
I mean the whoever's in,
right,
the investigators. But Sebastian's, I don't think it's cold, but hers is. But there's some reason they're trying to inject some more interest in this and putting out the reward.
I will.
The little bit I know of this story, the people she was around, the potentially nefarious people she was around, they might be motivated by a $47,000 reward.
I believe she already has a reward. I just don't remember.
It was small, though, comparatively.
Yeah, it was like 10,000, or it wasn't like.
Did she have an FBI reward?
I don't know.
I don't think so. I'll look.
But
that's right. That's right, Deanna. It's never too late to have new eyes becoming aware of older cases and helping bring awareness. There are older cases solved all the time.
Yeah. So I don't know. I don't. I mean, our audience is probably way more knowledgeable on Summer Walls than we are, but we could look at her story again at some point and try, just go through it. I don't know a lot of the details of it, but it might be.
So is Summer's color purple, guys? I'm guessing Summer's color is purple because I'm seeing some purple hearts in chat.
Yeah.
It's saying that her reward was not FBI. It was a community-based reward that was established by Church Hill Rescue Squad to incentivize information leading to Summer's discovery. The fund grew to over $73,000 through donations. It does not say. It says in February 2023, a court declared that the entirety of the award fund would be given to the Child Advocacy Center of the 3rd Judicial District.
Oh, that's what
so it sounds like saying. That the reward's basically gone now. It sounds like
Shirley C was saying that. I'm sorry. Yes.
I want to read this from Seth. It says, I've had several conversations about Summer with Atnight, mainly about the lack of police engagement and the case going cold, things that I don't want to happen with my son.
That's admirable.
Mm-hmm. And really the difference, the big difference for Summer and Sebastian is that they have Seth as the advocate here.
Yes, we've said this all along.
Yeah. Summer doesn't have a Seth fighting for her.
This group, I think, kept this money. Sounds like they kept the money and they still have it because it says on the news report, it says reward for finding Summer Wells now over 75,000. So it was dispersed to this group, but I don't know if this group has held on to it. That was a news article from June of last year.
I bet Don would know, but I'm sure he's off to bed.
Yeah. Yeah. People are confused by that in the chat too. I don't know. I mean, I know
We know so very little about this case.
Yeah, it's not a case that we started with.
When we I know one thing that happened when we first got monetized, we were like, well, maybe we should do, maybe we could have some kind of fundraising, whatever, and maybe we could contribute to a reward or something.
Yeah, we did.
We were talking about that, and then as soon as we started looking at the
logistics,
the legal,
right?
I mean,
it was very complicated.
Doing rewards is dangerous almost legally. Just to even offer one, you can get yourself in a ton of trouble with them. So we were like, yeah, know what, we're just not going to do anything like that because it was a mess.
And Real Me Too says Seth, his army will never let that happen, and Sebastian has you fighting for him.
Yeah,
very sweet. And then Astrology for Mystic says, Seth, Sebastian's father, police engagement is a huge problem in missing kids cases. I can't imagine the frustration, anger, and grief. I agree. Yeah, I did know that, Ginger, that they had lost custody of all their other children.
Yeah.
And they said, Teresa said there's a new sheriff coming into Hawkins County, so that's interesting.
Well, now that
there's a new sheriff in town.
No, maybe that's part of the reason. Maybe that's what Atnight's thinking now. New leadership, maybe fresh eyes.
Mm-hmm.
I mean, really, just getting a new detective sometimes on a case has broken them before.
And
they revisit what they thought was a dead end or a bad tip, and then it was something, and never know.
And Real Me Too earlier said, Mrs. E, you look so tired. She wasn't in. Well, I know I do, guys. She wasn't in here earlier. I was at the emergency room most of the night yesterday for several hours with Middle E.
And it's late for us.
Yeah, it's late for us. We would have been asleep about an hour or so.
Oh gosh, I didn't realize how late it was.
I know.
We'll never try to think we're going to do 2 streams in one night ever again.
If you remember,
because we just now are finishing one.
We started thinking, 26 pages. We'll be done with that in an hour.
Well, because you've read like 150 pages.
We weren't even close. We did like I don't know how many hours we've gone. 4, 5, I don't know.
3 hours and 42 minutes.
But we appreciate you. Jules Tucali, thank you so much. She says, look up the steps to collecting an FBI reward. It's a lot and not guaranteed.
Oh, I'm sure it is.
Oh, we did a long time ago, didn't we?
Yeah, of course. I mean, they there's all the controversy about how much good they do, but they do catch eyes. Those big numbers catch eyes. So to me, it's more about I'm not worrying so much about the rewards ever being paid out. It's just eye-catching. It gets your attention that reward's even being offered.
Right.
The big substantial ones,
And it gets people talking again. It gets people, somebody who wasn't motivated in the past might be motivated in the future to help.
I mean, you're driving down the interstate and you look up and you see $447,000 with a kid's face beside it. You're giving it a second look than you are maybe just the typical missing poster that kind of just looks like every other missing poster you've ever seen, so it's a eye grabber.
I will tell you though, this particular, I can't stop looking at it.
I know.
The picture? Yeah.
It's the contrast in the colors.
I don't know who did. Someone at night at night did it, but it is beautiful.
Yeah, really good.
It's almost like artwork. I mean, really, the way it's done.
Yeah. There's a power.
Oh, thank you, Rob, for becoming a new member.
Oh, thanks, Rob.
Sorry, Ginger, for Rob. She says, I'll be sleeping late tomorrow.
Oh,
sorry,
Ginger,
sorry.
you go to bed, girl.
We're
Don't worry about us.
We're kind of wrapping up anyway, I suppose, aren't we?
Yeah, it's almost 12:30 my time.
Well, I just want to say thank you, Eileen, for Mary O'Malley. That's a mouthful. I watch, but don't really comment much. I just wanted to say I appreciate your channel. You're so kind and calm and use sense. So thank you very much for
Common
this
sense.
oasis. Oh, common sense. I'm sleepy too. Thank you very much for this oasis. Well, we appreciate you being here. We really do.
Thank you, Eileen. We appreciate it very much. Well, great. Well, I thanks for following that with us. And we've got so many things we want to do on just different things that have happened, just angles. We've got some other media that we want to talk about in relation to Sebastian, and that'll be our plan next.
Well, I've already got it scheduled for tomorrow.
I've actually got it all set up already too.
Yeah, he was working on that.
Yeah, I've got it ready to go.
Yeah. And Rob, again, thank you for becoming a new member, and thank you to all of our new members tonight. I am going to start playing the music. So if you don't like the music, turn down your speakers and headphones, because I'm going to play a couple of videos to welcome our new members.
Thank you, everybody. And thank you to the mods, all the subscribers, and appreciate y'all hanging with us, and y'all have a great night.
You're not listening at all. This is, here we go again.
What?
I said I was going to play the dog pound video.
Oh, you are? Oh, okay.
I'm telling you, all day long. I have been saying this all day long. I have been saying it all day long. You do not listen to my words.
I guess I've proven your point.
Oh, stars. All right. Oh my. Okay.
Oh, we're off the rails now.
No, it's crazy. It's getting crazy.
I thought that was it.
No, that was the
members.
No, that's not welcome to the dog pound. That's the thank you for gifting memberships.
Oh, sorry.
Welcome to the dog pound. Your crime dog now, members only. Welcome to the dog pound. Your crime dog now, members only. Welcome to the pound, members only. Bow wow 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 wow. Doo doo doo.
Thank you so much to all of our new members. And then
I want to grab a prayer request real quick.
Sure.
Shirley C says prayer request for a creator that worked very hard on the Summer Wells case. She goes by Christine 55555, 43 years old, being treated for spinal cancer and brain cancer. Oh my God.
Oh my goodness. Well, yeah, absolutely. So I want to write. Do you have a pen? I want to write that down. If you weren't here earlier,
a prayer page so that we can add all of our.
I have one for our members on Discord. There's a prayer. There's a prayer page, but I don't know how to.
Maybe you could add one on YouTube on our community page.
I could add your prayers here, like a community post, and then let people put it underneath it. Yeah. Okay, I want to write that down real quick. Let's see. Christine.
She was in remission for 4 months. Well, I'm not familiar with her, but I'm so sorry to hear that.
Yeah, that's terrible.
So it's 5 5s. Okay. Okay. Prayer. Okay, I've got it.
Kelsey says, for some reason, gifting memberships is not showing on $. I have iOS.
It's not? I don't know. Oh, when I'm on my phone, I can't gift. Are you able to gift when you're on I've never been able to gift on my phone. I have to go to my computer. But yeah, I can do that. I'll just do a prayer request. I am probably going to do a post about, prayers for our son for the MRI on the 22nd. So
Ginger said she wished we could have a prayer group, but it would be hard to meet and it would be difficult.
I'll tell you what we could do. I wonder if we could do a prayer group on Facebook, or where we could have, you know what, Ginger, if you think about it, email me. We might be able to do something where we could do
She said, please do.
Okay.
Coming in late.
We've only been talking about it for 4 hours.
We're thinking about it. I'm just kidding, Tanya. Yeah, we already did. We talked about it.
You may have to rewind a bit.
Yeah.
Yeah.
But that's okay. You can join the replay.
Ginger doesn't have Facebook.
Well, okay, I don't blame you. So
yeah, we can figure out a different forum though.
Let's see. If anybody has any ideas, will you let me know?
That got you, Auntie, right? Yeah.
It got me tickled too, I have to say.
Yeah, Tanya, if you can go back from the beginning, we read through the whole thing and discuss it. So
we were just kind of winding things up.
It's just funny because I know, but thanks for coming in, and yeah, you could catch it on the replay there. We basically just give our opinion and thoughts as we go through. Okay,
Ginger, thank you for emailing me. Perfect. I probably won't look at it tonight because I'm really sleepy, but I will get back with you. I think that's a great idea. I'll just have to figure out what would be the best way to do it. All right, I think. Yeah, that's what I'm thinking too, Deanna. We may just do we could do a StreamYard or maybe not even have to be live. Can't we do StreamYard without? Oh, we can't we? I'm sleepy. I need to think.
Real Me Too said we should read it again.
Yeah.
Okay, you first. Okay, we're gonna drop you a link and let you start reading it. No,
that was a tough one. There were a lot of tough,
legal
phrases that I'm not familiar with. Yeah.
Well, we appreciate all you guys. I am not going to put you through all the super chat songs and stuff because it's late, and I know that Brittany J and some other people are live, I'm sure. So if you do go over to visit Brittany or any of our other friends, Josh or Justin or whoever, let them know we said hello and that Brittany did that earlier in hers, or she was like, go see Mr. and Mrs. E.
Yes, and that's very sweet of her to do.
And I'm sure Brittany has a live scheduled, and we're probably really cutting into it. And I apologize. We usually don't go this late. So
no, I have to get up and go to the farmer's market in the morning. So
she said, "I love y'all, but I'm still confused about it."
I was about to click the same thing. I mean, I am too. It was a lot. Yeah. It was a lot.
Well, we appreciate you guys, and I am going to wrap this up for tonight. And we know that you can be anywhere, and you chose to be with us, and that means a lot. We really appreciate it.
Thank you, guys. Have a good evening. Guys,
thank you.
I haven't set the video.
Happy Easter.
Yes.
Oh, right. Well, we're going to see him tomorrow.
Yes, but for those that can't make it, Happy Easter.
Oh, we want to put Suzanne M.
She was asking about the Christine.
Mm-hmm.
So I was going through chemo at the same time she was going through hers. Mine was pancreatic. But
I hope you're doing well, Suzanne.
Yeah, I think they were saying that she's got spinal and brain.
Do we know what type?
He started out as triple negative breast cancer.
Mm-hmm.
Oh my God!
And then it was in remission for 4 months, and then came back. That's what they're saying.
Well, Auntie and I are both cancer survivors, and so is little E. So we understand. So, and prayers to you, Suzanne, and prayers to Christine 5555 and Hobo for Life and Nana and all the people.
Yeah, a lot going on there.
And I'm going to wrap it up now, guys. You all have a wonderful night.
Thank you, everybody. Appreciate you hanging with us.
Join us tomorrow.
Bye.
We remember you. We remember you. Ooh. We're still here for you. We'll shine a light for you. We're holding on a hope for you. We'll shine our light for you. We're holding on to hope for you. We're holding on to hope for you. Ooh. We remember you. We remember you. We're still here for you. We'll shine our light for you. We remember you. We remember you. We're still here for you. We'll shine our light for you. We remember you. We